Can you please look up this site?
See if we can figure out something.
Well, this is awkward. Oh, there we go. It's happening. It's happening. Is it? Did it work? It's not working for me. Let's see if I can send a message. It's just stuck on that screen. Man, it really annoys me. Okay, now we're all back. Close that. Close that. Well, I saw someone commented about Judge Simpson having a soft sit this morning. Was it Thomas that we were following? Thomas. Oh, there we go. Thomas Styron. Hair in my mouth. Little Miss was first. I had to jump. Judy, I think it's because we're impatient. It does actually get there. I even got a notification. Well, if you did, the judge did. Let's close that up. Close that. Psychosaurus sent me the link for all the trials that they are monitoring. Oh, Judge Simpson's here. Sorry, I need to turn off the heart, but I will do that in a sec. Just let me get this to share.
Bonilla.
Bonilla.
Yeah. What about that house?
He arranged that housing on his own. I'm not really sure.
I get it, but why can't, I mean, I'll call Cedric, the gentleman that we spoke to today, and see if they have any more openings at the house.
Sure, yeah. I mean, it's just not something I can offer him. So that's why.
So let me give you a phone number. We spoke to a guy yesterday by the name of Cedric, right? And they have, it's called the Los
Angeles house.
Yeah. Good morning, Mr. Bueno. We're gonna try to find you a house for somewhere for you to go. First, though, the first thing we need to do is we have to do something called a TRAS. That's an evaluation to see what kind of services you may need. Okay, please be honest.
I was talking to a lady yesterday. I can't read, but I got her number, her name, the paper, and my brother had talked to her. I mean, my brother's trying to talk to her right now, trying to get in touch with her, and he's gonna give her the money to go because she wants a group home, and
We're working on finding you a group home. We had a gentleman in here yesterday who found a home that was willing to keep him. And what I'm going to do is I'm going to reach out to them to see if they will take you as well. Okay. But first things first.
I wanted to go to that lady group home in Missouri City.
Say it again.
I'm gonna go to a lady group home in Missouri City. She charged $600, and I got the money tomorrow. I get a check every month. I get it done.
Well, let's do this first. Save your money. I'm going to try to get it to you for free so you don't have to spend money. Okay.
No, I wanted to go to her house because she sounded really nice and stuff, and she said she.
Will you give the number to Alan so he can verify
I
that?
called her twice and I did leave a voicemail. I haven't received a call back yet.
She said she'd leave her a voicemail and she was gonna get back in touch with him.
Well, let's see if she gets back in touch with Alan. If she does, then I'm okay with it as well.
Okay.
But first things first, we're going to send you. Hi. Can you mind scheduling us a TRAS for Mr. Bueno and in custody ASAP? How long do you think it'll take?
So.
Do you know?
Them, I'll let them know.
Okay.
So right now, it's going to be searching. But I'll let them know.
August 12th. For in custody too,
I'll email them for email or let them know.
or if you want, I mean, I can reach out to them too. Perhaps we can kind of see if there's any kind, little pressures. I don't know.
Usually
know?
I email them and say that the judge is listening.
Yeah, will you please? And then before we reset this, Alan, let's see how far of a date she gives.
Thank you, Your Honor.
When you go, be honest, okay? Just be honest with all the questions they ask you, because if not, it's not going to be any help.
I really wanted to go to Lady Group home. I got her numbers.
Yeah, we'll get you there. We will get you there one way or the other. But first things, we want to have you evaluated to see,
Because my brother's about to give her the money tomorrow.
okay? I'm with you, Mr. Bueno. We will get you into the house, but first, get this evaluation done. I'm going to try to get it to you as quick as possible.
What violation is it?
Say it- What do you say?
What kind of violation is it talking about?
To see what other services you may need other than just housing.
I don't need housing. I just need a group home.
But you also take medication, correct?
Yeah, she gives a medication. She said she's gonna take me to a psychiatrist. The lady.
This is who I'm having you talk to.
We're gonna.
That's who I'm having you talk to now.
Here for free.
I don't want it for free. I got Medicaid. I can pay for my own doctors. I got United Healthcare. I don't want nothing free. I just want to go to the group home where I can pay money.
First, I want you to do the TRAS, then we'll get you to the group home, okay?
What's his T-Rex?
I'll have Alan explain it to you,
Okay.
okay?
I'm gonna take it back there, okay?
I gotta go back to custody.
Just until the TRAS is done. After that is done, we're gonna get you out into a group home, okay? I promise you I'm working with you.
I want to go to Miss Daisy. Daisy. I got her number, I got her name.
Okay, we'll work it with you,
I'm gonna
okay?
call it again and see if we can arrange something, okay?
Mr. Bueno, everybody here is trying to help you out.
Yeah.
Okay?
We got you,
They're
Mr.
gonna get
Bueno.
you
We're
where
gonna
they
take
need
care
you
of you.
to go to, and where you want to go, they're gonna help you. All right?
Okay.
Come on back this way, and Alan will be able to talk to you better.
And just let me know if you find, look, I got this note from Victoria.
Oh, sorry.
We have to do arraignments first.
I just wanted to offer both. I mean, we did offer time served. We even wrote it up, but he last minute said he didn't want it. So I
It's
thought we'll
okay,
just kind of-
great. I think this is even better. I mean, so we stop picking
I
cases
give him
up.
both options. So when the TRAS suggests something, like this is one option. this is
I'm not
the
gonna
other.
take TRS. I'm TRS. I'm not gonna take a time serve so that we can fix or help resolve the issue. So, I mean, we're working what? 15 cases now? Oh, it stops.
Thank you, Your Honor.
Okay, thanks, Alan.
Antonio Harrington.
Yeah. Come up, Mr. Arrington. I think they spelled your name wrong, unless it's really like that. Is it Antonio Arrington or how do I?
Antonio, but like it's been
Is there an
error
extra?
on my ID since birth, and I never they spell it
So the way they spelled it like this, it's correct.
the how it is on my ID, but it's not
And-
correct.
Antonio is how it's, I have. it. Can't be right.
No, it ain't right. It ain't
You
right.
want me to keep it like that? Mr. Arrington, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir. Okay,
Thank you, Your Honor. On July 24th, 2024, the defendant and the complaining witness were having a verbal argument over the defendant checking in the complainant's phone. And he saw that she was texting other guys. The complainant and the defendant were pushing and yelling at each other. The complainant is the defendant's girlfriend.
okay.
Complainant stated that he never hit her and she didn't hit him. Witness, however, stated that she heard a female yelling for help, and the witness saw the defendant punching the CW and choking her. Both the defendant and the complainant were in the car with the door open, so the witness could see what was happening. The complainant was trying to get out, and the defendant was pulling her into the car. Officers observed a scratch on the complainant's right arm, no other injuries. The complainant was not being very cooperative.
Do we know if she wants to have contact with him or no? Don't.
Your Honor, it doesn't look like the root cause was completed by DVD.
Okay, Mr. Arrington,
Yeah, complainant did tell back that he did not assault her and that nothing happened.
okay, Mr. Arrington, I'm gonna find that there's probable cause to go forward with your case. A protective order was issued in this case on the 25th of this month. I suggest that you get to know it. If you do something to violate the protective order, the state can and will file a violation of a protective order against you. It's one of the worst cases you can pick up. You violate conditions on a VPO, I can hold you at no bond, and I will do it in a second to protect every person of Harris County. Do you understand? I am ordering you until I know that she wants to have contact with you. I'm ordering you as a condition of your bond, not to have any contact with her and not to be in possession of weapons. Do you understand? How old are you, sir? You're 30. What do you do for a living?
To work at Papa John's.
Doing what?
I work at Papa John's, right? I drive box trucks, my bro got business and
So how much money do you make a month, would you say?
I'll be back soon.
it's hard to say.
What'd you say? 11
I
teen?
said, give or take, it's hard to say right now, you know. I'm still new to Texas, so I'm trying to figure everything out. I'm from Mississippi.
Okay, so we're gonna reset your case to give you time to hire a lawyer then?
Speak.
No, not about the case. I've got a bunch of DAs here. Everything that you say, they're gonna sit there, they're gonna write it down, and they're gonna use it against you to prove guilt. I'm trying to protect you from yourself, you know? Now, I know you wanna fight the case, just now it's not the time to do it. You'll get the opportunity, but you need a lawyer to do it. You're facing a lot of time. Not only that, you know, a conviction like this, you get an affirmative finding of family violence, meaning that you pick up another one, you'll be facing up to 10 years in prison, and you can never own a gun or ammunition. So there are serious, serious consequences. So that's what I'm saying. You need a lawyer to represent you. We'll reset your case to give you time to hire a lawyer. I'm gonna have you go to Ramona, sign a reset. After that, I'll have you go to the jury box while we get your bond conditions. We'll have you sign it. And after that, you'll be free to go. While you're on bond, do not pick up any new cases. Be nice. Otherwise, there's only one place you're gonna go. You understand, sir? Come on. Do you mind? Yeah, state conditions, yeah. Do you mind filing no contact and no weapons? Great.
Carrie Smith,
Yes.
Judge, page 18, Carrie Smith.
Okay. Good morning, Lily.
Thank you.
Good morning, Ms. Smith. Ma'am, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
So Judge, on July 24th, 2024, officers responded to a minor accident call for service in Harris County, Texas. Upon arrival, officers observed the vehicle resting in a ditch. Officer then saw the defendant exit the vehicle from the driver's seat and was the sole occupant. Officers observed the defendant to have strong odor of alcoholic beverage, watery bloodshot eyes, and slurred speech. SFSCs were conducted, 6 out of 6 HGN, walk and turn. The defendant refused to participate due to physical disability, and one leg stand was 3 out of 4. DIC red, consented to breath, 0.279, 0.270. The defendant stated she consumed 2 alcoholic beverages, commonly known as Rumple Mints. Her first DWI was back in 2002, convicted 2003.
She have a Texas driver license? Have you seen?
Let me double check.
Ms. Smith, I am going to find that there's probable cause to go forward with the case. At a 2-7, that would normally put everyone on the floor. I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you continue to consume alcohol, I will put you in jail. If you continue to consume alcohol, even when you're out, I will put you in a rehab facility. And it's a 9-month program if you respond to treatment well. Do you understand?
Yes, sir.
No alcohol means no alcohol from any source. No cakes, candies, foods, gums, tequila, lollipops, motor oil, hair dye. I've heard it all. Do you understand, man?
She's eligible. Her last suspension was the ALR.
Um,
Back in November.
Do you have valid liability insurance in your name?
Yes.
I am ordering you as a condition of your bond not to drive any vehicle that it's not equipped with an ignition interlock. If you're caught driving a vehicle that doesn't have an interlock on it, likewise, you will go to jail and I will take your privilege to drive permanently away from you. Do you understand? How old are you, man? What do you do for a living?
I am unemployed at the moment. I watch my niece and I do random odd jobs.
Like what? How do you, how do you support yourself? You need money in life.
I watch my niece. I get paid for that. And I am helping my mom start her LLC. And I get paid for that sometimes as well.
Did you want to apply for an appointed lawyer, ma'am?
Yes.
Okay, I will give you an application. We'll have you fill it out. I will take a look at it. I need to know everything about you, what kind of car you drive, how many cars you have, stocks, bonds, mutual funds, IRAs, and then I'll take a look at it. And if you qualify, which you probably will, I'll appoint you a lawyer today. Okay, ma'am, but I'm serious when I mean no alcohol. You, understand this. You got out of jail because we gave you a free bond. If we put your bond at $5,000 to $10,000 and you don't have anyone to pony up the money, what happens? You'll be stuck like Chuck, right?
Yes, sir.
Consider that when you're out there. Okay. I'll have you go, there, we'll give you an application. I will have you go to Ramona, sign a reset, and then we'll have you take your seat in the jury box while we find your lawyer. Yes. Hey, good morning.
How are you?
What's new, man?
Same old, same old.
I feel your pain.
Nothing's changed much in 30 years, Judge.
Well, you look good for 30 years.
I have David Palomino on your docket, Judge. It's a racing case. Gavin Ellis has the case because the person my client was allegedly racing was an off-duty police officer. So it's with public integrity. But we spoke yesterday.
So did they charge the other person as well?
Yes, they did.
They did? Okay.
We spoke yesterday and we spoke, we've been texting back and forth about an amicable resolution. So I think it'll end up a PTI type deal.
Okay. So what happened with the off-duty officer? Did he get in trouble? Did he get reprimanded?
They've charged him and public integrity has it. And I don't know what's gonna happen with it.
Because we need officers, right? We hope that probably, well, I don't know. So it's only 130 days old. It's not too terribly old, but it's getting up there. We'll give you 30 days. Have you guys relayed the offer yet, or has Gavin
No,
relayed
Judge,
it?
The only reason why is Gavin, he got called out to an officer involved shooting, so he's not here today. That's why I'm talking on this case. I can't
Okay.
relate any officer on this case and stuff.
Right.
Sounds like they're reaching a resolution.
Okay, I guess you want 30 days? What do you want?
We should have it worked out before.
Yeah, okay, all right, for sure, thanks. Top of 13, Palomino, just a normal reset, and it's still waived. Do we have any more arraignments? No? That's it for arraignments? Any THAs?
Yes, after this.
Hey, Chris.
Hey, good morning, Judge.
Morning.
I have two cases under docket, Your Honor. The first one is Caden Slack.
Is that with an S?
With an S, yes, Your Honor.
Okay.
Judge, we're going the PTI route on this one. Right now, we're in the process of putting together the packet. He's a 0.18.
So he'll need a mitigation packet then?
Correct, Judge.
Okay, it's 160 days, so we'll give you just a couple more weeks, and he's got to be here at the next setting, so we can send him for our TRAS.
Okay, understood, Your Honor. And then the other one is
Like
Jess.
2 to
Smith.
3 weeks, okay?
Okay.
And then let me talk with Ramona to get you a date. And who's your second
Okay.
guy?
And the other one is Jessica Smith. Same deal, Your Honor, except we don't need a mitigation packet for this one.
Okay. That one I can give you a little bit longer because it's only 136 days. So we can give you a full 30-day on that one.
Okay.
Just bear with me a second, then I'll get you a date.
Okay, thank you, Judge.
Well, if you want to help Brian first, well, please. Bottom of page 17, Slack. So 2 to 3 weeks, getting a mitigation packet done, and then they're going to appear here to get a TRS done. We'll walk through.
So it's 21st, August 21st.
August 21st-ish.
That works, Your Honor.
Is it 21st a good date for you?
It's a good day, Judge.
Okay. And then the top of the next page, top of 18, just a normal reset.
On that one, what's gonna happen? What are they doing?
They're also doing, yeah, well, no, but just a normal application on that one, but they can have a full reset.
What are they doing?
PTI. They're gonna apply for PTI. But they don't need a mitigation on that one.
Okay. Do you want the same day or do you want?
No, longer. Do you want the same day or do you want longer, Chris?
Oh, if we can get longer, Judge.
September 11th?
September 11th?
Can we do the 10th, please?
Sure. Okay, it's yours.
Thank you, Judge. Maybe excuse.
Okay, man, have fun. Yeah.
Your Honor, you too.
Hey.
Morning, Judge.
Hi, Mr. Mercer.
Ashley Grant.
Okay. Is she here?
She is, Judge.
What are we doing with Ms. Grant?
So she's been kicked out of VWI PTI.
Okay.
Repeated positive.
Oh, that's right. She didn't make it here last time.
Yes, sir.
Okay.
Which was my fault, because I didn't.
Yeah, that's right. I'm not dinging her otherwise, right? She'd be in custody. So we just need to know what did she do, didn't she do? And state, are you okay with keeping her on or no? I guess that's.
Yeah, I just know, the Nathan, she's up.
She's out. Okay, sorry. Come up, Ms. Grant.
Yes, sir. That's sort of information. We have,
Yep, she need to make that decision today.
yes, sir.
Ms. Grant, come on up. You know, one day you're gonna look back on today and you're gonna kick yourself 15 times. Why did I make this thing work? Such an idiot. It's just, and I'm sorry, it's not my decision whether to keep you on or not. It's not my program. It's the DA's program. But they require strict compliance, and when you don't, there are consequences. So that is, now we need to decide what you want to do. So I will have you talk with Mr. Mercer. You must accept either today the plea bargain from the state, or otherwise we will set your case for trial. Okay, please. And then you tell me.
I think we've got a decision already, Judge. We already spoke about it.
Okay, what do you want to do?
Time, sir.
Okay, have you written it up yet?
I'm doing that right now.
Okay, so if you just want to take the seat back over there, we'll have Michael explain to you all the paperwork while you sign it, and we'll get it done and get you. Okay?
Thank
Thank you, Judge.
For sure. Logan, did she just abscond or did she pick up a new charge? What happened?
No, Your Honor, it was several high blows. She admitted to drinking alcohol to the CSO to cope with the death of her grandmother.
Couple with what?
Cope with the death of her grandmother. And it was 50-something high blows over the course of like 6 months.
Okay.
Thank you. And then she never completed SOP.
She never what?
Completed SOP.
That's interesting.
There's a court martial in the service check today. They're both here.
Got it. Okay. Oh, I think this is for you too. That's good.
Sorry, Judge, 46 IBR, BRACs over at
46. Oof. Oh my God. You're drinking a ton. Well, she's gonna regret it now, that's for sure. Do you have, hey, I'm sorry, what was your name? Riley? Okay, Riley, do you have, on Mr. Starks, do you have proof that he's been in the classes, in the completed classes? Yeah. Like, because I'm not gonna take, how do you know that he's been doing well? Because, like, I'm not gonna take his word for it, you know?
Negative.
She told us that she called the transfer this morning and they exceeded that.
She was able to verify with the consent. Okay, great. I mean, I trust Torian, so that's great. Okay. How much do we know? How many classes? Where's Torian? She back there? She's back there. And this. This.
Yes.
I've got a couple of cases in this board on September.
You don't have to deal with me? You don't have to deal with me?
Yes. Yeah.
Sorry, I was sitting by the heater looking at movies that I've saved in Disney, in the Disney app, because I forgot Some of my favorites. Just checking law and crime quick. Nothing yet from court. Yes, I'm very surprised that people missed Barbie movie because it was such a big box office thing. There is a Billie Eilish song that I learned to play on piano, but I can't listen to it because it makes me cry. I also have my Barbies because my mom said I mustn't give them away because I'll regret it one day. And I didn't think, I thought she was like exaggerating a bit. And true as can be, I kept all my Barbies, and I, after the Barbie movie, went and grabbed them, and I was like, oh. I had that Ken, the weird Ken with the earring and the leather thing. Toy Story really made me sad about my toys. I felt so bad. Judy, if you're going to watch Charlie and the Chocolate Factory, please watch the Johnny Depp one. It is phenomenal. I wasn't allowed to watch Bambi because my mom said it would just upset me, which is a good point. If I watch the movie home, I cry like the tiniest little baby, and I just want my mommy, and nothing can help that. I have to literally be with her. So yeah. Fox and the Hound. Oh, that also broke my heart. 101 Dalmatians I loved, but now that I'm older, I'm like, ooh, it's a bit of a weird one. Jen, you can actually get quite a lot of them. Well, when the movie was big, they were all priced insanely, but I've started replacing some of the stuff that I have either lost over the years or it's been donated. Like Beauty and the Beast is my favorite ever because Belle is me and I am Belle. Her nose is stuck in a book. She's a bit weird because she just wants to read. She doesn't want to people. People don't understand her because she's up, her head's up in the clouds. That's me. That was my entire childhood. I didn't want to socialize. I just wanted to read, and I didn't want anything that was going to disturb my reading. I still love reading so much. And I found Beauty and the Beast book at hospice. I think it's in the lounge at the moment, but the exact one I used to have. So I bought it so that I'm like starting to collect these things. I also thought of my mom, but like in the way of like her being a person and having a childhood, and it's gonna make me emotional. In case you can't tell, insanely attached to my mom. Like I could live in her pocket and I'd be happy. Okay, since there's nothing from court, just quickly want to see. I don't know why I have a feeling that there's someone in Judge Simpson's court today that we were meant to see. It doesn't look like I know this guy. What I want to do is get one of those huge calendars that you can rub off the writing so that I can keep track of these things because the notebook is just not doing it. Oh, Little Mermaid as well. Oh, Little Mermaid. She is also classic ADHD, 100%. Like, I toggle between like which one is my favorite. And I loved Little Mermaid, the real version. I loved it. I like that whenever, like the other day when I went to hospice, when I get home, the first thing I do is look at this stuff. Isn't it neat? Wouldn't you think my collection's complete? That is like that, all the treasures. Oh, and another thing about Beauty and the Beast, the reason why I could understand hospice is thrift shopping. The reason why Belle was my favorite was because I always said the way to my heart is just buying me a library. That's it. I don't need all the fancy things. When the Beast gives her the library, I'm like, no wonder she fell in love with him, obviously.
Mr. Starks, come on up.
Sorry, it's the hospice
Logan, this is a probation case that we're having. It's an admonishment.
charity as a shop.
You're doing good. You're getting there. Don't miss any classes. You've got 6 done. You've got, what, 12 more to do, right? This is the way that you get this thing dismissed. As I was telling the other gentleman, this kind of case, if you end up with a conviction, has really, really serious consequences.
Sorry, since I won't be able to interrupt the trial for a long time, I might as well get all my talking out now. On the story of books, so because we all like trial watching, you'd probably enjoy Jodi Picoult's books that have trials in. I read the honey one, the one about the bees, that recent one. I read that, and the lawyer in that is the lawyer from 19 Minutes, which is the one that Columbine, that one, the one that's similar to that. So I got that on my Kindle and I started reading again. The only thing is I want to read the physical book, but that version of it that I bought at the time was huge. So it's a bit of like I love reading on my Kindle, especially when I travel, because I can have it in my handbag and read on trains and whatever. But that trial is so good because the main character is a judge. And so Jodi went and researched, and as far as I know, lived with the judge, followed the judge, like, to see how things go. It's really good. That's kind of the vibe that I used to love reading. This is 19 Minutes. 19 Minutes. Jodi Picoult. I always said Picoult, but it's Picoult. Such a good book. Such a good book. Tarzan was my son's favorite. Great soundtrack too, but made me cry. There's actually a theory that Tarzan... What is the theory? My sisters told me these things. So Elsa and Anna's parents in Frozen die in a shipwreck. There's a theory that they're all connected, and I can't remember what the theory is. Frozen is another one that I love, especially because I can relate to Let It Go. That was like my theme song when I was in news. Because I'd be like eating breakfast and seeing like which is the worst murder, and people are like, something's wrong with you. Hey, we're just busy talking about kids' movies. And recommendations of kids' movies. So what was I saying now? I was talking about Frozen. Love Elsa. I also appreciate if you watch Frozen and you look at not Kristoff, the other one that Anna finish each other's sandwiches, classic narcissist. Like, if you want to explain a bad person in a cartoon form, it is him. Everything that she does, he just will transform to be that. And it's only because he wants to be the hero and take the whole castle over, etc. Love it. Here we go. Elsa and Anna's parents set sail. Ship sinks. Seen at the bottom of the ocean in Little Mermaid. They're stranded and have baby Tarzan. How crazy are these theories? But they're probably true. Also, Walt Disney mapped out Disneyland while he was essentially dying in hospital. On the ceiling of the hospital, he mapped it out. And as far as I know, the reason why the reimagined versions come out now of the movies we loved when we were kids is because he wanted the reimagined movies for us to be like reliving our childhood, but in a different way. So that's why it's generally not movies that, one, kids would watch, like Little Mermaid. Don't think kids should have watched that. And two, it's not like recent movies. Oh, movement in court. We'll give them a few minutes.
All you have to do is show up for 12 weeks and then it's gold. Do you understand? Don't you miss one. It's all over. We're going to set you off 30 days and I want you to come back for one more compliance check just to make sure that you're doing well. And then we'll set you off further if you're in compliance. Okay? All right, man, go ahead, take a seat. We'll be back with you here momentarily. Eddie Mendoza.
Also, I hope your little one feels better soon.
Is it?
Not really, no, not if I'm okay.
Right. You have been on probation since August of last year, and you have done nothing.
I actually have signed up for classes, sir. I don't know if that shows yet. I've been taking a couple already.
I don't care about signing up. I don't care that you sign up because we tell you to come here to court and that's what causes you to get things done. I don't think so. Take a seat for me in the jury box.
Can't tell if the camera is shaking because they're trying to get angles right in the Massachusetts court, or if it's because they're about to come back in.
It's minor sense. So what are we doing?
Also, if I missed your comments, I'm sorry. I'm just keeping tabs on this live.
You're right.
I'm also hoping that the defense doesn't want to bring up the autopsy pictures of Tan again.
You ready?
Yes, sir.
Miss Grant, you will forever in a day remember this because, you know, the problem is that this conviction will go on your record. It will be there for the rest of your life. You can never, ever take it off. You must also understand that from now on, you'll be facing a minimum of 30 days in jail for any cases that you pick up, don't matter what it is. If you ever get pulled over and an officer, run your plates, because that's the first thing they do. They want to know who they're dealing with. The first thing they do is they will look at your criminal history. They're forever will see that you have a DWI in your record. If they roll up to your window, if they smell alcohol, if they smell marijuana, they smell anything funky, what do you think is going to happen? Right. Don't give him a reason. I would never, even if you've had half of a beer, because to me, it seems like you like to drink. If you're gonna do it, because Logan, how many?
I believe it was 46 over the course of 2 or 3 months.
46 blows of positive over the course of 2 months. That tells me that you like to drink. If you're gonna do it at home, wonderful. Don't get into a car. What we're doing today will not happen again. Do you understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, you can never change this or undo this. You understand? How do you plead to the offense of driving while intoxicated? I will find you guilty, sentence you to 3 days in jail. I will give you credit for the 2 days that you've done. I am going to suspend your license for 180 days. Do not drive until you get a license. I'm telling you, if you get in a car and drive, it's a Class B misdemeanor, just like a DWI. You will be right back in here. And it's not going to go well for you if we see you back in here. Okay, good luck, man. I'll roll her court costs so she won't owe anything, because she's probably paid quite a bit for the program. But I'm telling you now, I will have absolutely no sympathy if you come back here with a new DWI. That tells me you have learned nothing. And what we do to little children who don't learn, we punish them somehow. And what we do, just like a child, will put you on our knee, spank you with a ton of jail time, just like a child. All right, good luck. Thanks, Mr. President.
Judge, you did one CC?
Yeah.
Judge,
Yeah, but just a 180-day suspension.
Judge Alfonso that you took into custody yesterday. So he wanted out, but he didn't get out till 5 a.m. and he hitched a ride with somebody else that was released. No, he's not here. He doesn't have a ride today. So he wanted to know if he could get a reset for
Tomorrow.
tomorrow.
If he fails to come tomorrow, tell him I will triple the bond. Yeah, SFBF tomorrow. I understand. I get it that he was released at 5 in the morning, but no.
So basically, what we can gather so far is that husband was an alcoholic in recovery. They had been in a bit of a tumultuous relationship for many years. He had cheated on her. She became obsessed with the cheating, and the mistress, who also testified. And essentially then, after they had an argument, he allegedly ran into the knife. And when her daughter called 911, and when they spoke to the responders, they said that he was having a heart attack. However, he had been stabbed twice. And so yesterday, the judge mentioned that for self-defense, the defense are going to have to look into the jury instructions and really go through it with a fine-tooth comb. And so we were looking at it, and unfortunately, just going on what we have so far from the Commonwealth, it does look like there is no grounds for her to be not guilty. Nothing, not even a little bit. So we're waiting for the medical examiner to come back. But this morning, the judge had a note last night that the streams were picking up whispers at the Commonwealth's table. However, we heard a little bit of hot mics like in between. We couldn't hear whispering that much. So until Law and Crime could figure out how to stop that from happening, we were kicked out of the courtroom. And so we missed part of the child that I think knows the most, part of his testimony. So yeah, now we're waiting for medical examiner. And then after that, the state will rest and defense will start theirs, as far as I know, tomorrow. Stabbed in the back, yes. From what I've heard on just the Commonwealth, I obviously am waiting for the defense, but from what I've heard, it's not looking good for her. I do think that she was having a terribly hard time with his addiction and with the cheating. But the law there is such that it's not looking good. Little Miss, when I did this with Vaughn last night, it did seem possible, right? Like I said, if she was holding it because she had a tendency to want to do that. If she was like this, because she didn't hit any bone. So if she didn't hit bone, from what we could tell from our limited science, is it couldn't have gone top down. It would have to go bottom up. So either like that, or it was like that, and then the impact was there. She was definitely getting a little too involved and a little too, she was reaching the point of being controlling, and I can understand it, but he was, from the evidence we have so far, her life was not in immediate danger from him. I think she was more likely in danger of herself. But in Massachusetts, it has to be him. In fact, there, it can't even be, like if he had been pointing the gun at the child, from what we read yesterday, she still wouldn't be able to defend the child and get away with it. But they are still working on the jury instructions. So we'll have to see where they land with that one. And it does look a bit like we have a situation where it's going to be a stretch for the jury to be on her side without her testifying, even though she shouldn't have to, because there were no witnesses. She is kind of, I think that if they can make her more human, it could go well. I do get incredibly nervous when they're late, though, because they're supposed to be back 15, 20 minutes ago. I'm scared that they're just going to cut off the feed. Actually, Benefield verdict really upset me. Really upset me. I believe her, and most of the people who I saw in chat saying like they believed she was guilty, it was, I didn't believe her, not that it was the forensics. Hi, Mirabelle. How could he run into the knife backwards with enough force? Oh, Jen, the prosecutors, when they made her reenact it, that was incredibly triggering, like horrible. I don't know about I may have to go back and look at the autopsy stuff that I didn't show and maybe like recreate it less graphic, with less graphics. Also, in case you haven't been here before and you're wondering why I covered the screen of the autopsy, here, based on our journalism ethics, you just never show somebody's autopsy. You never show their body. It needs to be, you need to show things that the victim and the victim's family is like okay with. So we would never broadcast that on TV. It's too graphic. Like basically the standards that we go by is news that's accurate, comment that's fair, programming that is not harmful to children, does not amount to hate speech, doesn't contain explicit violence, gratuitous, something. Yeah, basically like extremely violent is out. Muse sentence, 20 years. Oh. And this is why I struggle with juries, because that was another one I didn't agree with. I simply cannot understand how anyone watching the video of him and watching the video of those kids, how? Awful.
No excuse for tomorrow if he's not here.
Sorry, Lisa. I should have said spoiler alert. That Apple River trial, I actually had nightmares about that happening to me. Judy, it's absolutely fine. If you don't believe her, that's absolutely fine. I really don't mind people disagreeing with me. For me, it's just because I have lived experience of no physical wounds, but being scared of things. Like I mentioned the other day, like if someone sighs, immediately I'm in like fight or flight. That's quite there's no bruises.
Did Ramona do the guardian interlock?
Where are they? Is it still live?
Did you do the guardian interlock paperwork for Miss Smith? You didn't.
Same, the Apple River trial haunted me. I don't understand how you would not be terrified with that going on. The camera's not even moving in the trial.
Attorneys in my office, but I'm.
Oh, baby journo. I mean, baby,
they're all telling.
Baby lawyer.
Hey.
Good morning, Judge. How are you?
Morning. Come on
May
up.
we approach?
Yes, ma'am.
What's going on?
You said last name was?
On Marcus Perez.
Okay.
But I was just going to introduce you to my dear friend Sachi.
Hi, nice to
Sachi
meet
is
you.
going into her senior year of high school, and
Oh,
she's
nice.
in law school. So she's kind of
Wonderful.
checking out the courthouse this week.
It's fun and it's.
Several judges have told her to run fast and far. They're all telling her, run.
What? Why? The judge is
Why?
telling you this? Hell, no, don't listen to that. No, there's no better profession than being a lawyer. You learn so much information, it's sick. And the thing is that no one can take advantage of you. no one can take advantage of you in this life if you know things. And you know things by going to law school because they teach you just a crazy amount of just abstract information that you would never even think about, like uniform commercial code. You know, there's this one theory in the law called adverse possession, where if you take a piece of property and make it like your own for a prescribed time, you can basically take it from someone underneath them. Yeah, it's crazy. Just so many things that you learn just from going to law school, even if you don't become a lawyer.
What she has learned down here this week, she said the most thing she's learned is that people are really weird. Very weird.
Well, I mean, where are we?
It's true.
No,
It is true. She may have also been talking about some of the attorneys in my office, but I mean, it's fine.
you know,
It's fine.
It makes for an interesting time. Right?
It has been very.
It's a fun gig. And you know, when you're a lawyer, if you treat the profession well, it'll pay you back in dividends. I mean, it'll pay you like God. Right.
I think
So-
journalism
She's interested in international law, so
Well, I don't know anything about international
she's gonna do
law.
well.
I don't know. I can't tell you anything about that. I don't know what kind of money they make. I don't know how interesting it is. It's probably just all contract work. You sit there and read at a desk all day. I don't know. But you don't try cases like what we do.
Yeah, this has been fun.
It's fun.
It's a special kind of person, really. It does, but it's fun. I would say yes. Do it.
Do it.
But just in
See,
cases.
I think you're the first
Don't
person
listen to
tell
anyone
her
else.
that.
Thank you,
Oh.
thank you.
Is he the first one to say do it? I feel like everyone has said.
Yeah, everyone's been a little.
I can't believe that. I
Yeah.
really can't. You know, this is just, it's the greatest job in the world. You know, I'm telling you, if you treat it well, you can make so much money. I had a friend that made $350 million a couple months ago on a judgment.
Wow.
And then a month later, he makes another 60 million.
Yeah.
Really. So I'm telling you, if you treat it well, if you study hard, if you do your research, it'll pay you. It really will. Not like us in criminal.
Yeah,
It's still fun, really.
it is. It is.
Ask her. She does whatever she wants to do. Kim does whatever she wants to do. She don't want to work. She don't want to work. She's not gonna go.
I only get yelled at sometimes, so. See?
I would. Boss.
Thank you.
Thank you.
Camera moved tiny bit. I think journalism is better, but when I was job shadowing, likewise, all the people in radio were like, do not do it. Do not do it. It's hard. You don't get paid well. It's stressful. It's this and it's that. And I was like, you know what? I don't care about getting paid. I want to do it. And I did it. And I loved it. And court is back. And I learned things in journalism that I use every day, including here.
This court's now in session, be seated, please.
Any further cross-examination?
No further cross-examination, thank you.
All right. Any redirect? No, Your Honor. The witness may step down. Commonwealth may call its next witness. The Commonwealth rests, Your Honor. So what that means, jurors, is that the Commonwealth haven't had its opportunity and has now completed the evidence that it wishes to present in this case. I'm going to see the lawyers at the side of the bench.
So he said he was going to continue more than 5 minutes after. And then they go on break. Also, I have to go back a little bit because I don't have subtitles at this point.
Commonwealth haven't had its opportunity.
So they go on lunch for 26 minutes longer than anticipated. Come back and he doesn't carry on questioning. Also, I've had this chair for like just over a month and it's squeaky. I thought he finished before lunch. I was under the impression, because if he was finishing before lunch, why not just say to the state then, do you have any redirect? And then the state could say no, and they could send the witness off. Happy days. Also, after the scolding this morning, we don't have the beeping. I really feel like a mint ice cream, but that feels like a terrible idea with a sore tooth. If it was me on trial, I would get a notebook and I would get writing prompts, and I would not listen to anything. I would try, in an ideal world, and just write creative writing. Because anything you do, people are going to hold your facial expressions against you. They're going to read into every second. They're going to break down and analyze why something happened. And like for me, I absolutely hate eye contact. I hate it. It really freaks me out. So I tend to like divert from eye contact, which would immediately look like I'm shady, because people have been told, like, when you lie, you don't maintain eye contact. Oh, I hate silence because, like, I don't like anticipating the sound, because I have sensory processing disorder. So like sound is so intense for me, and I'm kind of scared I'm going to get a fright. My shoulders are very tense, by the way. Ooh. There's an update in the Uber driver self-defense case. William Brock. I just want to see when his court date is. When is his court case? Also, if this is going to take a little while, we can do this, make everyone happy.
Radio up and the blinds pulled down. You love it when nobody's around. I wanna call out round town, but you bite my lip, don't make a sound. I'll be damned if I'm leaving without you.
Oh, I am so scared of the dark. I'm not scared of monsters, I'm scared of humans.
So give me a minute to catch my breath. Take what's yours, I'll take what's left. I'm used to coming up second best. Always fail to pass the test. I'll be damned if I'm leaving without you.
So they don't say when the next one is.
So jurors, I'm going to send you off for your day. I will tell you that I expect that the evidence in the case will close at some point tomorrow. And then we'll move on to the other phases of the case. So tomorrow will be a full day for you. And you may in fact get the case tomorrow, but no promises as to that. It's a possibility. I just don't know how things are going to turn out. So be obedient to your rules, please, jurors. I know you've been obedient to them. At this point in the case, as I said, you probably could recite them and start asking each other. Don't do that, but be obedient to those rules. Don't talk to anyone about this case. Don't do any research about this case, and continue to have open minds until you reach the time that you'll deliberate the case. Have a good night.
Court, rise for the adjournment, this place is no book.
Oh, jurors. I almost sent you back out without the most important part. You do not need to be here until 10 a.m. tomorrow. I don't want you here waiting around for us. Be here at 10 a.m. ready to work, all right?
Jurors, please exit this way.
Yep, jury's going home. Starting at 10 tomorrow.
Let me take a moment to look at the motion. All right. Defendant presented a motion for a required finding of not guilty at the close of the Commonwealth's case. I've read the motion, Attorney Wood.
I'm asking you to allow my motion, but in particular with regard to the charge under the theory of extreme atrocity and cruelty. I think under the circumstances and given the nature of the evidence that charge or under that theory should not go to the jury.
Commonwealth is arguing.
I don't know what that means.
Your Honor, at this stage, the Commonwealth suggested in the light most favorable of the Commonwealth that the charge of extreme atrocity or cruelty should go to the jury. As Your Honor is aware, the Castillo case from 2020 informs on how to determine that element of extreme atrocity and cruelty. And these arguments kind of dovetail into the argument for jury instruction as well. But in this circumstance, the revised instruction in the model, the SJC model instruction on homicide, identifies three particular factors. And they're commonly referred to in common law and in prior case laws, the commune factors, and the Castillo obviously kind of revises the order or the importance of those particular categories. Instead of making them several separate and distinct factors, it kind of groups them into three. And so in this particular circumstance, the Commonwealth alleges that there are a couple different elements of the extreme atrocity and cruelty prong that, in the light most favorable to the Commonwealth, are present in this particular case, based on the evidence and all reasonable inferences that can be drawn from that evidence, including one, that the defendant was indifferent as to the injuries. And again, we're not talking about the specific intent of the defendant, the intention of the defendant to inflict extreme atrocity or cruelty by her actions, but it's the conduct and whether that conduct meets the criteria of the element. And so for indifference in this circumstance, the Commonwealth would allege that in this circumstance, based on the evidence, it's not clear that, as defendant promised in opening, that this all happened in a short 15-minute time frame. What you do have before you, Your Honor, is that the last time Michael Ricci is seen by somebody outside the household was 2 o'clock that afternoon of January 28th when he goes to the Dunkin' Donuts drive-thru. And you have testimony from Sophia that she gets home from school around 2 in the afternoon. I believe her testimony, based on my recollection, is that she doesn't recall exactly seeing her dad when she came home from school, but she knows both of her parents were home that afternoon. And she heard them. She went right up to her room. She was in her room for the entire afternoon. She heard throughout the course of the afternoon yelling from both of her parents, loud noises. I think she described them as bangs. And it wasn't until 4:45, right before she made that 911 call, when she's called downstairs by her mother, alerted that something had happened. And she discovers and she finds at that time that her father's already on the floor and he's unconscious and not breathing. So we do have a bigger time span than what was alluded to by the defendant in his opening statement about how long this interaction lasted and when this event could have occurred. You also heard from the medical examiner that the nature of that injury and the fact that there was significant injury internally that resulted from the stab wound itself could have led to the unconsciousness of the victim a matter of minutes or longer. So I would suggest, and again, based on reasonable inferences, that the nature of that injury and how it was inflicted and the time frame suggests that the defendant didn't take immediate action, and that is a level of indifference. It also suggests that the injury of itself was excessive and out of proportion. As Your Honor is aware, under the Glass case, which is cited in the model instructions, a single blow is sufficient. And again, a single stab wound, a fatal stab wound, could be sufficient. In here, we have 2 stab wounds, but I think it's clear based on the medical examiner's testimony that wound to the chest that caused all that internal damage was essentially the fatal injury. And that in that injury, the extent of that injury, the victim had accumulated half of his blood volume in his chest that was still there at the time of the autopsy. So I'd suggest that the nature of that particular, the extent of that particular injury is excessive and out of proportion. And I would also suggest that in that third prong, that the method and means, again, based on those other factors that can be considered, where one of those factors does include the level of suffering, the likelihood of substantial increase of conscious suffering of the victim, based on the medical examiner's testimony about what an individual feels or could feel or is likely to feel in receiving that type of injury, the pain of the wound, the loss of breath, the increased heart rate before losing consciousness, that all goes to pain and consciousness. And again, we're not saying that it's just based on what he felt, but these are things that not only did he feel, but the defendant being right there over him at the time would have seen him exhibit. And again, based on the fact that she inflicted that conduct, I think that meets that prong as well. So I'd ask that you deny the motion as to extreme atrocity and cruelty.
So with regard to the 3 Canine factors, the
Castillo factors.
Well, I'm talking, yes, they're Castillo, but they're
They were
taken
revised in
over and
Canine,
revised
right.
under Canine and referenced as that by the Commonwealth. I don't think that they just applied those factors correctly. Factor number one is not whether or not he suffered any pain. That's not the question. The question is whether under portion 2 is whether the defendant's method or means of killing the deceased was reasonably likely to substantially increase or prolong the conscious suffering of the deceased. And the question of indifference or pleasure, which is part 1 of that test, doesn't relate to a potential person. It relates to this individual case. So let's talk about it in this individual case. The medical examiner's testimony was that a person with there's one fatal wound, and someone with such a fatal wound would be dead within seconds to minutes, not more than minutes, seconds to minutes. One would be hard pressed to find a smaller interval by which someone could say that the death occurred when it is recreated in retrospect. Essentially what this was a penetrative wound to the heart in which the person bled out extremely quickly. We also have testimony from the EMT, Cohen, who says, when we got there were no vital signs at all, and we wouldn't have changed our protocol anyway, because when you have no vital signs, the first part is just to get the vital sign back up. He did say, a stab wound that's actively bleeding, you put pressure on. But at the time when there's no vital signs, our procedure is always the same, which is to get the vital sign back. There is no evidence whatsoever that this was a prolonged and suffering death, and they don't get there by simply saying that the medical examiner talked about a potential or a possible fact that there could have been as many as minutes, and then that the defendant could have perhaps been aware of it. What we know is that at 4:45, I don't think there's any evidence that this happened outside of a 15-minute period, by the way. The mere fact that they were home and arguing, that's not the relevant thing that we're talking about as far as what led to this event. It's the escalation where it goes from an ordinary argument to a situation in which there's combat going on. And that does take place over a very short period of time based on Sophia's testimony. She says they're arguing, and then all of a sudden she hears banging, which presumably is bodies moving things around and falling. And then she hears her mother call 911. It wasn't like there's evidence that there was some laying back and waiting a period of time by Ms. Ricci such that there could have been additional suffering before she mentioned something to Christine Ricci. So the 3 Canine factors or the Castillo factors are whether the defendant was indifferent or took pleasure in the suffering of the deceased. Even in the light most favorable to the Commonwealth, there just isn't evidence about that. The only evidence about what happened during that 15-minute period is Ms. Ricci's statements. With regard to the nature of the injuries, the fact that having a trauma like this causes bleeding, that it causes bleeding quickly, that the bleeding is internally, none of that answers that question. Secondly, whether the defendant's method or means of killing the deceased was reasonably likely or to substantially increase or prolong the consciousness of suffering of the deceased. We just have no evidence about that. We have a single stab wound, and that was fatal, and we don't have any evidence that something was done by the defendant to prolong the suffering. Third is whether the method used by the defendant were excessive and out of proportion to what would be needed to kill a person. This is a person going above and beyond what is necessary for death. There's also no evidence of that. There's no indication that there were additional stab wounds after the first fatal one in which, there was some anger like you have in some cases. There wasn't, evidence of surrounding behavior that would suggest that something was done to the body after the fatal blow. There's none of those things. We just don't have any evidence on any 3 of the Castillo factors. And yes, anytime there's a death, there's going to be a trauma which causes the death, and there is going to be physical symptoms that result from that trauma. Otherwise, there wouldn't be a death. But beyond the fact that there was death here, you have essentially the story of death and nothing more. You don't have a story of someone acting extremely or atrocious, particularly as it's understood under Castillo. And it has to permit them to find it beyond a reasonable doubt. And of course, we don't have any evidence on that.
Right. In your argument, the 2 of you reference as is appropriate, the Latimer standard, which is drawing all reasonable inferences in favor of the Commonwealth, whether or not the issue is whether or not after drawing those reasonable inferences, it's legally sufficient to permit the jury to consider this case, and much of the argument has focused on this cruel and atrocious, extreme atrocity and cruelty argument. I'll circle back to the other arguments as well in a minute. And whether or not there's sufficient evidence before the jury in the evidence and reasonable inferences that can be drawn from that evidence to submit it to them on this theory. Although Castillo streamlined and revised the factors articulated in Canine, they did not abrogate the factors in Canine. They sort of reclassified them, put them in different categories. So in making this decision, I rely on law that precedes 2020 that does refer back to those Canine factors, which I think are equally appropriate today. I looked at these in the evening based on the fact that I knew that at some point we're going to be doing a jury charge this afternoon. And I was really focused on the issue of I think it's too narrow to say that the evidence supports it's a single stab wound. It's a single stab wound that kills the deceased. But the evidence before this jury is that there was another significant wound. When that happened, during the timing of that argument, is left for argument, it seems. I do not recall Sophia Ricci's testimony being so definite that the banging that she referred to in her testimony, that was part of the argument. When that happened, vis-a-vis when she was called down, I don't think is before this jury. Your recollection of the evidence will control, but she heard a verbal argument that she could not hear the contents of, and there was banging also before she was called down. There are different inferences that can be drawn from that evidence and the existence of two wounds to the defendant as to what transpired. And as you know, nobody that has testified was there. And of course, nobody has an obligation to testify in any way. But there are reasonable arguments and inferences that can be drawn from the testimony that's before this jury. So I focused on the issue of a single fatal blow, even though I don't think that quite captures the evidence in the light most favorable to the Commonwealth that is here before. But both Glass, Commonwealth versus Glass 401, Mass 799 and 802 and 803, where the court found that a single stab wound where the defendant turned the knife to inflict more injury, that is distinguishable from this case, but a single stab wound. Commonwealth versus Eau Claire, which is at 444 Mass 348 at 361 to 365. Commonwealth versus Eisen, 358 Mass, 740 at 746. Support the idea that the case can be submitted and should be submitted to the jury on extreme atrocity and cruelty in the instances, all of them factually sensitive, of course, but in the instances where the victim was killed with a single blow. I also have looked at, and I'm going to continue to look at tonight, Commonwealth versus Doherty and its progeny, 353 Mass 197, a case in which a sleeping victim was roused and then shot at close range. The jury could conclude that the victim had, quote, some awareness of what was being done to him, and that therein made it proper for the instruction with regard to cruel and atrocious. I will continue to look at the cases on this, and I expect that this will be a discussion, further discussion after council's had an opportunity to look at those cases. But at the present time, my thinking is, and my ruling is, that there is sufficient evidence drawing all reasonable inferences in favor of the Commonwealth to submit this case on the second theory, that being extreme atrocity and cruelty. With regard to the other charges, both the theory of deliberate premeditation and the second charge of assault and battery as a dangerous weapon. Again, drawing those inferences entirely in favor of the Commonwealth has met out its burden to get over the hump of submitting this to the jury under Latimer as to each of the elements with regard to deliberate premeditation, and also with regard to each of the elements on assault and battery with a dangerous weapon. So at this time, defendant's motion with regard to required finding of not guilty is denied. I want to turn next to the defendant's.
Was that a directed verdict, basically?
What I'd like to have is the actual medical records in front of me and have an understanding of precisely what the defense is asking for, because it seems that to the court that there were dueling motions that we addressed some time ago. It was either at the last final pretrial conference or at the one before that, because we had a couple. And they relate to paper number 162 and paper number 166, which are dueling motions with regard to the admission of portions of privileged records and the Commonwealth's opposition to that. Whenever we last visited this issue, I told the defense that my preliminary ruling with regard to this is I did not see a path to admissibility of these records in light of the patient psychotherapist statutory privilege that's codified at Mass General Laws, Chapter 233, Section 20B, and it has a number of exceptions. I don't think that any of those exceptions apply to this case, but something that you said to me at the side of the bench caught my attention, which was that you were no longer seeking to perhaps admit all of the things that you asked. If it's some other more narrow part than in your motion, paper number 162, what is it? And I want the records in front of me so that I can be looking at them real time.
This is the more limited version.
And is this part of the last exhibit number 57?
No, this is on the Sweeney Dolly medical record that I mentioned in the motion. It would just be the diagnostic portion. Can we give a copy to the Commonwealth of the portion of the record?
Can you give it to them?
Yes.
Sure.
Yeah, I redacted.
Okay.
Yeah, I
I was
redacted.
like,
No, I redacted.
Okay. I see it. What's your argument?
My argument is that under section 503, as well as under 233, section 79, that's 503, section 503 of the Massachusetts Act of Evidence, which talks about psychiatric patient exception or privilege and its exceptions. Under 503, section 503, it's clear that what is covered by that privilege is communication. A diagnosis in and of itself is not a communication. It's not covered by the privilege, and it's distinct from Michael's statements, hearsay statements. Your Honor made her ruling based on Commonwealth versus McLaughlin, which were, of course, hearsay statements in that case, not from medical record, but coming in for a self-serving purpose, meaning the defendant's out-of-court statements to come in for sort of a self-serving purpose. That's not what this is. This is a diagnostic statement written or written by a provider, of a healthcare provider. We believe other statements, like for example, are for diagnosis. That's why we included them in the original motion, which is also an exception, like the part that is essentially the Sweeney Dolly record is essentially a diagnostic document. And these are the statements that are being used to create diagnosis. So I want to preserve my objection, but obviously the diagnosis itself is not a self-serving statement, or it's certainly not a statement taken out of context. It's just a diagnosis. And therefore, I think that comes in, particularly where the Commonwealth has put on evidence that maybe Michael wasn't suffering from any mental illness. It was all the creation of Christine, and that Christine was the one that was diagnosing him. And the fact that we have a diagnosis of a medical provider, I think is relevant, and it is an invited response to that line of government argument. And I think the situation has changed between now and when these arguments were originally made. And I no longer think, once you wash the record of many of the statements of Michael's to the provider to get the diagnosis, I think a lot of the McLaughlin language is no longer applicable. And obviously, the 23379, from my perspective, doesn't apply to the diagnosis itself.
Your Honor, I would suggest that the situation hasn't changed at this point, even based on the state of the evidence and what came in at trial. As stated in the Commonwealth's opposition, the issue here, and Your Honor alluded to the privilege, is that 23379 doesn't make the privilege go away, and that the privilege might still override the 23379. 23379 does allow for medical record exception, but only those portions related to treatment and history, and they have to have some presumption of reliability. So the Commonwealth's contention is that these records, or even just this particular one record, that one page in a series of records that just identifies a potential for diagnosis, doesn't provide enough information or context to suggest that diagnosis was, that there was anything that supports that diagnosis provided by this particular provider. And I would suggest that based on the fact that these records are very limited, that if you look at the rest of the records that were summoned in, there is no conversation or no records or notes from the provider that identifies how that diagnosis was reached, and if she even reached that diagnosis. It could have been a diagnosis that was reported to her from previous providers. These are also records that occurred between the dates of June and September of 2019. But if Your Honor were to look at the docket in this case and see how many different records were summoned in to the court, and how many, there are even additional records that were summoned via grand jury for Michael Ricci. He had various treatment providers over a period of time, including other providers that provided treatment closer in time to his death that do not come to that same conclusion as far as diagnosis. And so by allowing the defendant to admit this one record, we're putting one statement without any indicia of its reliability, without any information to suggest that the clinician themselves came to this conclusion based on their contact with Michael. And we're parsing out a bigger history that ultimately isn't relevant in this case, as Your Honor had initially stated. I did cite to an unpublished case in my pleadings. I have a copy of it for counsel in the court if you would like the copy. That it involves a juvenile situation where a judge did exclude information and treatment records that did have to do with mental health, because there was not enough information to suggest the context in which that statement being offered was, there wasn't enough context for that statement, and they found it to be a more generalized notation. And that suggests that's what this is.
Is the defense prepared to have the provider submit to a voir dire so that the court can determine whether there is any reliability to this diagnosis?
Well, I think they're admissible. Well, I am, but I do have a problem with the provider. The provider is not in the country right now. She left a day ago, and I secured her presence at a time when I thought it was going to be plenty of time in order. I summoned her, but because we had the delay from the previous trial, it ran into a vacation, and now she's gone. But I think these come in actually under Rule 17 as well as under the Section 78 of. They came into the clerk's office with an affidavit.
How old was the defendant when he passed?
He was
Excuse
50.
me, the decedent when he passed.
He was 51.
Why does it say on the first page of this that his age is 54?
It's because of when they printed the
How
record.
am I supposed to determine that? That goes to the reliability of what's in this record.
Oh, but can we say this?
Get
That
her
there's
in, get somebody in there that's the record maker. Before I'm going to even consider preliminarily whether this should be admitted, I have to know that this information is reliable. And when the date is obviously wrong on the front page, and there's no affidavit that goes with that to explain that, that makes me just an initial, not even dealing with the legal issues. What is this document and where is this document coming from?
This is the affidavit of the record holder as well as the record itself. And what you can see is the record was printed out at 7/29/24, and based on that, he would in fact be 54 years old. I think it's.
I didn't ask when it was printed out. I'm looking at this document that you're asking me to put before this jury. And before I do so, I'm going to want assurances and even consider the legal issues of whether it is or it is not included within the prohibitions of the patient psychotherapist. As you say, it is not. And by the way, I will say that I've looked at cases that indicate that that diagnosis is, but I'm happy to go back and look at that again. But as a preliminary determination, I have to have belief that what I'm putting before this jury is reliable. And when the basic information with regard to the age of the defendant, the patient, is not correct.
So Your Honor is saying that you think it's possible that maybe they got the age wrong and that the age was not updated by the computer based on the day that they printed it?
I don't know, counsel. That's beyond
You
my,
think the court doesn't
that's
know?
beyond my powers.
Really? Okay, well, I would say this, Your
Counsel,
Honor.
don't start
No,
with
I'm
that.
not saying anything. I would just say this. I obviously can't get the person in here because they're out of the country. I would just ask this. If I'm not able to put that in and there is a medical record that suggests that there was such a diagnosis, I'm asking that the Commonwealth be precluded and during their closing from making the argument that it was a invention of Christine Ricci. If I'm not able to put in the medical record because of the prohibitions that Your Honor has suggested and the obstacles that I cannot meet, given the fact that the keeper of records is not here and I can't do the voir dire, which would allow the court to, no, it's just her. She's the one that actually treated Michael Ricci. She's the keeper of records. She, before she went on vacation, she brought them in with a new affidavit so that they would be properly admitted under Section 79. So
Did that affidavit address the genesis of that?
I handed up
Diagnosis of bipolar? Was that something that she made or somebody else made that that was passed into that record? Does it address the merits?
Well, it addresses, I handed up the affidavit with the package of records. Your Honor, my suggestion is that not only is it clear from, there's a bunch of statements about that they used in order to make that diagnosis. And Your Honor said you're not going to let them in. And then the Commonwealth says, well, if we just have a diagnosis without the explanation of how she got there, then that can't come in. Well, we're being kept from putting in the statements that he made that led to that diagnosis. Just the diagnosis alone? Nope, not that without her presence saying how she came to the conclusion. Fine, but I think that Your Honor should then preclude the Commonwealth from being able to make an argument about the absence of evidence with regard to bipolar disorder, since they put into evidence that my client said it. So if they want it to be the case that I'm not allowed to explore that, I'm not allowed to put it in because these records aren't reliable, they shouldn't be able to argue the negative from that.
Your Honor, may I just briefly be heard? This might be of assistance for purposes of this argument. The Commonwealth does not plan on arguing that in its closing. With that said, that should also preclude the defense from making any argument about that potential diagnosis either.
Well, I'm going to, it's in evidence, the fact that my client said that, and I'm going
Said
to,
what?
said he was bipolar. It was put in by the Commonwealth. I think I can use that fact and rely on that fact as an advocate. But if they're going to then say this was something invented by Christine, I think that's a step too far if I'm not allowed to show that it was diagnosed by a doctor.
Well, I'm not going to deal with the closing arguments right now. I'm focused on this document and the admissibility of this document. And when I rule on that, I'll give you any further rulings with regard to the limitations on the openings and closings. I'm going to say on the state of the records that is here before me, you know, I'm sensitive to the fact that it's the summer and people have vacation plans. But this trial has pretty much gone off to the schedule that we expected it to go. Case started when it was supposed to start. It took a long time of impanelment. That's not unusual in a case like this. And the case has gone to the 5 days of evidence, as we indicated it would. So,
Your Honor, can I make a record about that? We were supposed to start trial on the 15th of July. We did not start trial, even starting jury selection, until July 22nd. I'm not blaming the court for that, but that when summonses were sent
if you knew you were
out.
going to have a witness issue, you should have brought it to my attention. And you did know as soon as we knew that date was going to get pushed. And there was no objection.
I knew that it was going to get pushed as soon, but only after I knew that Your Honor was keeping that evidence out. Then things.
Say that again?
Your Honor had ruled on my motion preliminarily before trial started and before we knew what day it started. So I had no reason to believe, given the state of the evidence, that I was going to be able to get this in. Then we had evidence in this case that I believed opened the door to this question. That was when trial was already going on. I then made an effort to
What is the evidence that you maintain was
Your Honor,
elicited in the case? I want you to go through that again so I can consider that.
Christine Ricci said bipolar.
Through who?
Through Officer Hunt, Officer Martin. We had testimony with regard to, from Mark saying, I knew that Christine was diagnosing him with stuff. We had.
Any mention of that beyond that generalized statement by Mark?
The son.
You mean, did he mention bipolar specifically? No, he said, I knew that Christine was diagnosing him with a bunch of stuff.
Right.
And that specifically, he said, and this
Friend.
obviously, this portion of the record obviously shows that portion of it is not true. So it is, the door got opened during trial. Once the trial was already underway, and I did the best I could, I contacted her lawyer, Joe Eisenstadt, spoke with him, arranged for her to bring in or to deliver to the court a new record with an affidavit, because the original Rule 17 summons didn't come in with an affidavit. She did that. Under our statutes, that should be, at least that's a medical record that should be self-authenticating. So I did not expect there to be a need to do a voir dire about it, but I understand Your Honor's position. But just know this, these events occurred and they were not foreseeable. They occurred during trial. And when I tried to remedy it, the plans were already made and she was already leaving the country within a 3-day period. So I did not have the opportunity, as Your Honor suggested, to plan in advance and make sure that I had witnesses here. It would sort of be akin to the situation that the Commonwealth described when it dealt with the Michael Ricci Jr. situation when he was going on vacation, which ended up not being a problem because of the delay in the trial.
Was the information, so the two sources of information that you indicated that have come out through the trial testimony that you think opens the door to this, this record being admissible, you state are through Officer Hunt and Officer Martin, that their testimony was that the defendant told them that he was bipolar?
Yeah, the statement that was taken at the scene was he's bipolar, and then once at bipolar schizophrenic, and he collapsed. That's Martin. And then Hunt says something like he was having a manic episode. That's the statement.
Manic episode is something different, and that's why I asked you specifically. And what I want to ask before, first of all, does the Commonwealth agree that that's what the evidence, that what Attorney Wood just said is the evidence? That is, that there was testimony by Officers Hunt and Martin that the defendant told them that he was bipolar. I remember schizophrenia. I remember manic.
Okay.
Repeatedly. I don't remember bipolar, but I'm not a computer.
The Commonwealth would agree with Your Honor's assessment. Officer Martin clearly testified in his report, also indicates that the statements from the defendant were that the victim, the alleged victim, was in a manic episode.
And was that information in the initial reports that were provided to the defendant?
Yes.
The manic, that's been consistent throughout.
Correct.
That is the statement that has come in of the defendant through those two witnesses was that he was in a manic state for a period of 3 days before, and that he was in a manic state on the day that the stabbing occurred, right? Was that in the reports?
That was, but the statement of the other officer was that this is, we were talking about Officer Hunt now. This is what was attributed to Christine Ricci based on my notes. That's what I've been saying. He's bipolar and schizophrenic.
So now, Your Honor, we have three different, in the span of minutes, we have three different statements from the defendant about what his mental health is, and only one that's reflected in this particular record and none of the other. So again, that questions the reliability of even the defendant's assessment of what the mental state of the victim was at the time of the incident occurred. And again, I would point to the court that the records from this particular provider are from 2019. We also have records from Pembroke Hospital, which is in September of 2020, closer in time to the time of this incident, where the diagnosis in those records that the defendant was originally trying to get in doesn't mention bipolar at all. It only mentions major depressive disorder.
With psychotic incidents, with psychosis.
Psychosis and bipolar are not the same thing. And to present that to the jury is extremely misleading without somebody to explain that information. And if I just may, before I forget this moment, because moments flee me, counsel just said that he had the provider provide new printed out records and an affidavit. Commonwealth does not have either of those things. All we have is the Rule 17 motion that was summoned into the court that we got months ago that have no affidavit with it.
That was a discussion at the sidebar when Attorney Wood was saying that these have been properly subpoenaed for trial, and I could see everybody on the other side indicating no by their verbal.
We know it came via Rule 17, but it did not have the proper medical certification page on it. And that is what we've always had. We don't have that affidavit.
But under the statute, it's supposed to go to the clerk's office. It's not supposed to go to either one of us, and it didn't go to either one of us. It went to the clerk's office under the statute, under section 79. It's to go to the clerk's office with proper certification. It did go to the clerk's office with proper certification right before trial. It doesn't need to go to the Commonwealth in order to be, that's not part of the process of summoning into the clerk's file. And when we talk about this idea of her saying manic versus bipolar disorder is two poles. One is depression and one is mania. So it's entailed, bipolar entails mania. So this idea that she wasn't hyper technical.
Psychiatric diagnoses from attorneys, all right?
No, I'm not saying,
First of all.
I'm not saying that, but that is a matter of, are we saying that the only way that we can get something confirmatory in is if the words match exactly. That seems also to be a hyper-technical, limited ruling.
They're highly different things in my experience, but I wouldn't even rely on my experience. That's why we have experts. That's why we have people. I'm not taking your vermin with regard to whether mania is included in bipolar or not, or whether they're different diagnoses entirely.
My objection is not that they are the same thing. My position is that her saying the words bipolar and them are saying bipolar in one instance, and then also saying mania could be related and this part of the same thing.
And that's why it would be good to have a mental health expert to explain the significance of that. But I don't have one.
Please note my objection.
I haven't ruled on it, but I know your objection. I'm going to give this back to you before I lose this nice sea of papers.
Did she say no? I feel like she did.
Expert.
Related and this part of the same thing.
And that's why it would be good to have a mental health expert to explain the significance of that. But I don't have one.
Please note my objection.
I haven't ruled on it, but I know your objection.
Psychosaurus Rex, they need a mental health expert. Stat. I disagree with the judge, for the record. But I'll explain what I was looking into. Adam, they should watch Bee Movie. It'll make them love bees. And you can watch it too, because the humor's top notch. Instead of being Jewish, they're bee-ish. Let's see how much I can fit in before she starts, before she says her ruling. Okay, so 23379. Here's it explained for a 5-year-old. In this case, a doctor wrote down notes about a patient's condition. These notes were used in court to show what the doctor observed and thought about the patient's health. The law says that these notes can be used in court even if the doctor isn't there to explain them. This is because the notes are considered
Jury instructions in a particular,
Can we take a break briefly to hit the bathroom before we get into jury instructions?
you may take a break.
Thank you.
probably a smoke break. We can hear prosecution whispering. Commonwealth. Andrew, you need to turn off the sound. We can hear Commonwealth. Okay, so it says, the law says these notes can be used in court even if the doctor isn't there to explain. This is because the notes are considered reliable since doctors write them as part of their job to help take care of patients. Vaughn? Oh, I think Phoebe sneezed. Did you guys hear that? So then I said, in what situations would they be allowed? The doctor's notes can be used in court in situations where the notes are made as part of the doctor's regular job of taking care of patients. The notes are meant to help with the patient's treatments, or the doctor isn't available to explain the notes in person. These rules make sure the notes are reliable and useful in court, even without the doctor being there to talk about them. So then I was trying to understand the specific thing that I was reading. And I said, what if the person in the notes is dead? Because the person that is in 23379 is still alive. If the person in the doctor's notes is dead, the notes can still be used in court. This is because the notes were made to help with the patient's treatment and are considered reliable. The fact that the person is no longer alive doesn't change the trustworthiness of the notes. The notes can still be used to understand what the doctor observed and did for the patients. So I said, why would it not be allowed? Then it says the doctor's notes might not be allowed in court if there's a reason to believe the notes are not trustworthy or were not made in the usual course of treating the patient. 2, hearsay rules. If the notes are considered hearsay and don't meet the exceptions that allow hearsay evidence to be used. 3, if the notes are not relevant to the case being tried. So then I asked, does the doctor always have to be in court? And it said, no, the doctor does not always have to be in court. The doctor's notes can be used as evidence if they are made as part of the regular treatment of the patient and are considered reliable. This is especially useful if the doctor cannot be present in court. However, if the reliability of the notes is questioned or if the court needs more explanation, the doctor might be required to testify in person. So basically, to go back to
the updated model SGC jury instructions on homicide and the dates that I am using.
sorry, since we're not like absolutely live in terms of the jury, I'm going to just finish this thought. So basically what happened here is the system that the psychologist was using to keep the records about the victim automatically updated his age based on his date of birth. And this is where I disagree with the judge, because she said they would have to have an affidavit, and he brought up an affidavit and she still said it's not reliable. But basically she said his age is wrong on the records, so it's not reliable. But his age also isn't technically wrong. It's just that he did not continue to age. But the computer would have gone date of birth this year, where are we now this year, and it would have auto-generated the age. She said, from my understanding, no mental health expert, it's not coming in. So they need someone, ideally this doctor, to be able to verify these. They might be able to, if they get creative, from my understanding, be able to get an expert to explain some of the mental health, but that doesn't mean that they can bring up his diagnosis. And then the part that Steve went back and listened to and summarized, in a nutshell, Commonwealth has met the burden necessary to not allow directed verdict for the main charges as well as the secondary charges, based off the Lattimore documents, which I think was their motion, I think. And sorry, I had to click my pen. Sorry. And what has been presented without anyone who was directly there testifying. So what the judge has basically said is there's enough evidence to go on, and that there's not enough for a directed verdict. I'll be surprised. Not at all. We've only ever seen 2, I think, in the entire time that most of us have watched court. And one of them was in Judge Fleischer, and the second one was like the next day somewhere else. Also, I absolutely love bees. I really want a bee tattoo. That needs someone to verify the records. But this is why I'm getting frustrated. According to my limited Google understanding with the help of ChatGPT, the laws that they are citing mean that an affidavit should have been enough. Because that verifies that the record giver is giving the documents according to what is true and accurate. This record giver is out of the country, is offline, is not available, cannot be in court. They are wanting this to come in because of, I actually counted 3 different people saying that Christine was like making up mental health problems. The best friend, the cop, and Michael Jr. I thought that all 3 of them were making it sound like the dad was stable and fine when clearly he wasn't. I think it's too broad to say, one saying bipolar, one saying manic, so they don't match up, because it could present in different ways for different people. My ADHD was originally misdiagnosed as bipolar, and my hyperactivity at times was seen as manic because I'm quite a chilled person a lot of the time. So it was his doctor who diagnosed him and treated him for bipolar disorder and major depressive disorder. Yes, his actual psychologist. But this was psychologist as in psychotherapist, not as in psychiatrist. So I don't know what it's like there, but here a psychiatrist is the only one who can give medication. A psychologist can't.
Publication date of August 15th, 2023, which includes the.
Sorry, I need to hear the beginning.
SGC jury instructions on homicide, and the date that I am using, publication date of August 15th, 2023, which includes the updated case law from 2020. Notably Castillo. So I think each of you have those instructions in front of you. Yes. Defense?
Yes.
But both agree that criminal responsibility is out and joint venture is out. I think you further agree that defense of another is out. I'm just going to those areas where I think you have agreement. I'm looking for you to tell me if I've got it wrong. You agree with regard to felony murder out. You agree that voluntary manslaughter absent a murder charge is out. You agree that charging of a minor with murder is out.
I'm listening to this because of the discussion yesterday. I know we generally skip your instructions.
You agree that it is too soon for any questions to the jury before questions from the jury, both of those are out. That is instruction that would be given before supplemental instruction and after supplemental instructions. And you agree that the instruction regarding after jury reports deadlock on murder in the first degree is inappropriate. And I agree with all of those things. That is, I think that that agreement is appropriate. Any other things you agree upon that I didn't list?
I think we agree on voluntary manslaughter as an independent instruction.
Do you agree on that?
No, the Commonwealth is asking that it be just the lesser included.
All right, we'll get to that. So let's talk about the disagreements. First, you disagree with regard to the propriety of the self-defense instruction. And defense believes it should be in, and the Commonwealth does not. I'll hear first from the defense.
The evidence in this case involves of what happened at the time of the death, involved mostly the statements of, it involves the testimony of Sophia that mom sounded panicked, mom was shaky, crying, trouble breathing when she came down and hyperventilating. During fights, dad acted aggravated/frustrated, including when he couldn't remember things about the affair. Mentioned the stuff about the differences in that Christine had a joint condition, often wore an arm brace, that the mother was, that Michael was more agitated once he started drinking and would raise his voice and all of a sudden get angry. There's a text message to Angel, which they introduced as exhibit number 4 with the words, "He was attacking me." There was testimony from Angel that that Christine had arthritis before the affair, wore a brace on the arm. Christine wore brace a lot, could stop her from doing certain things. Left hand, it's on her left hand, even though she's right-handed. According to the testimony, dad was significantly taller than mom. The testimony of Chris Martin was that Christine Ricci was frantic, hyperventilating, yelling, and screaming. Christine said to him, manic episode, suddenly collapsed, couldn't understand some parts. When talked to Christine again, she says there was an argument. She feared that he was having a manic episode, so she grabbed a knife. Christine said that she was scared. Michael lunged at her. From Hunt, we have Christine says she took a knife to defend herself. And from Hunt, we have Christine stated that Michael lunged at her. We have from Katrina the height differential. That's the evidentiary basis. Now, the law is that the evidentiary threshold for a defendant seeking instruction on self-defense is low. That's the Commonwealth versus Ortega on page at 480, Mass 603, on page 610. In determining whether evidence warrants an instruction of self-defense, we consider the evidence from any source and resolve all reasonable inferences in favor of the defendant. When deadly force is used, such as in this case, a defendant is entitled to instruction on self-defense where there's evidence permitting at least a reasonable doubt that the defendant reasonably and actually believed that he was in imminent, that the defendant was in imminent danger of death or serious bodily harm. That the defendant availed themselves of all proper means to avoid physical combat before resorting to the use of deadly force, and that he used no more force than was reasonably necessary in light of the circumstances. Here we have very little evidence about some of that information, at least the second two prongs. However, we do have all of this evidence with regard to the physical incapacity of the defendant, and the much larger stature of Michael. I know Your Honor mentioned of the situation of deadly force, and when deadly force is first initiated, it's a little bit different in a homicide case than in other kinds of cases because you're dealing with deadly force. I would suggest that even though there is case law that suggests that the moment that a person pulls a weapon is a moment of first aggression, that's not the case here. The testimony seems to be that, as I mentioned a moment ago, that essentially there was a knife pulled by her own statements to ward off Michael Ricci. In other words, he was manic and she felt scared and she grabbed a knife to ward him off, which wouldn't be the initiation of deadly force at that point.
What would be the initiation of
The
deadly?
pulling out of the knife. If it
Is
was
that
being,
consistent with the law?
yes.
Counsel?
Well, I think it's consistent with the law if we make a distinction between the situation in which a person pulls out a knife with the intention of using deadly force at that moment, whereas a person pulls out a knife for the purposes of warding someone off so that they don't get into a conflict. That would be an example in which they weren't attempting to use deadly force. I think the evidence in this case is that the moment of deadly force happens later, after this moment of lunging or maybe falling in a struggle that occurs at that time. So we don't have a situation like in some cases where a person goes and grabs a weapon and is intent to initiate the process of deadly force on their own as the first aggressor. We have a person who grabs a weapon with the intention, at least based on the statements, and in the light most favorable to the defendant, to ward off, which is non-deadly force. And then something happens which escalates somewhere along the way. And
And if I credit the defendant's own statement that he was manic and I was scared and I took the knife because I was scared. That's her statement to the police, is reported and now has been reported twice to the jury through two separate instances. That is frankly the only evidence this jury has right now of direct evidence of an account of what happened during that encounter between the defendant and the decedent.
Your Honor, there's also the text. I just want to remind you, the text Angel, he was attacking him. But attaching, but then it was corrected through testimony as being likely meant to be attacking.
So the two issues that I pointed you to Chambers, and Chambers really deals with the issue of in the context of homicide, and I'm reading from that case, as I told you yesterday. In the context of homicide, in terms of the definition of first aggressor, defendant may lose the right to claim self-defense only if he was the first to use or threaten deadly force. So your argument is in part viewing the evidence in the light most favorable to the defendant, largely based on that text.
Based on the text plus the statements, everything together.
Well,
plus
your
the-
statements alone doesn't help you, I don't think.
Plus the
because-
success.
But the statement alone doesn't help you because under the case law, it indicates that things such as throwing a punch, verbal altercations, and other acts to include instances of individuals being excited none of those things rise to the level of the first use of threatened or deadly force. So what she says to the police has been reported is not enough, I don't think, to entitle you to the self-defense instruction. I will go back and look at that text message. And I know the Commonwealth's going to say, well, that was just created after the fact, but I have to view that in the light most favorable to the defendant in terms of whether she's entitled to that instruction. But it seems to me, based on her own version reported to the police of what happened, she falls squarely within the prohibition of Chambers as to what is and is not permissible in terms of her claim to self-defense.
Could I say one thing?
Yes. And then
Taking out a knife in and of itself also is not a per se first aggressor deadly force situation.
isn't that what Chambers said?
No.
The critical question here in determining whether the Commonwealth has proved that the defendant did not act in self-defense when he killed the victim was who first grabbed the kitchen knife that ultimately was the instrument of death, not who shouted first or who struck the first punch, because it was the grabbing of the knife was the act that transformed a relatively harmless fight among roommates into a deadly altercation. Why doesn't that equally apply to this case?
Well, it's in that particular scenario in which people are just yelling at one another, somebody grabbing a knife with the intention of using deadly force, the grabbing of the knife is the beginning of that process, but that's not what's happening here. If you take the two statements together, the statements made to the police with the statement, he was attacking me, you have something that suggests that he was, plus the, you have a scenario in which there is a suggestion that this act of deadly force occurs while the attacking is going on. And that it may be the case that a knife is pulled at an earlier point when you take into account also all the evidence that's been put on with regard to suicide. There may be another reason why she pulls a knife out that doesn't have anything to do initially with Michael Sr., but it might become about Michael Sr. after there is this attacking, which is described in the text to Angel.
I hear your argument. I want to talk about.
I'm sorry, can the Commonwealth offer some cases that might shed light on the questions Your Honor is posed to counsel?
Yes.
So this idea that the defendant loses her right to claim self-defense when you're the first to introduce deadly force isn't new to Chambers. It's the common law principle, and it requires that in order for the defendant to be entitled to self-defense, there has to be, the defendant must raise reasonable doubt that there was a reasonable ground to believe, and actually did believe, that she was in imminent danger of death or serious bodily harm, for which she could only save herself by using deadly force. And I suggest that the distinction there is, it has to be reasonable and that they actually did. The fact is, this defendant went and armed herself with a knife before she even did anything. She tells the police that I went to go grab the knife to scare him. She does make a statement that she was scared, but I'd suggest that her statement that she was scared isn't enough. In Commonwealth versus Reed, it's an SJC case from 1998, 427 Mass 100 is the site from 1998. It says that even though the defendant in that case testified that he became scared immediately before the stabbing, there was no other interaction that raised that level to a means in which deadly force would have been the applicable or the correct action, or would have entitled them to self-defense. She went to the kitchen, she got her knife, she said that she was scared, she told the police she grabbed it to scare him. She didn't tell the police she grabbed it to protect herself. She said it was to scare him. And then she continued to identify that she used it and created the idea that he first lunged at her when she used it. There is consistent case law. I have Commonwealth versus Gonzalez with a Z, 465 Mass 672. It's an SGC case from 2013 that involved the stabbing, where the defendant in that case told police immediately after the incident that he was defending himself from a group of individuals who were trying to jump him and kill him. And in that case, the SJC said the fact that he made that broad statement about defending self without any specific actions as to what he was defending from wasn't enough to give him the entitlement to the self-defense instruction. That there was no specifics to suggest or infer that the victim in that case was actively participating in the jumping of the defendant or of the threat to his life, and therefore he's not entitled to that defense. And I suggest similarly in this case, there is nothing before the court, even based on her own statements, to suggest that the victim did anything to make her actually believe that she was in fear of imminent bodily harm or death. The other thing that, so the two other things that the defendant, that needs to be considered when the defendant is asking for self-defense, and again, this goes back to common law versus Harris, is an SJC case from 1978. The second thing is that the defendant has to avail themselves of all proper means to avoid physical contact. And we haven't talked about that yet.
I get to that next.
But there is some testimony before the court. There is plenty of testimony before the court. That the victim fell in the area between the dining room and the living room. There's been some suggestion, I would say, through questions of counsel, that maybe something happened in the kitchen and that the victim's body was closer to the kitchen than in the dining room. But we do know that from that kitchen, there's two ways to exit. There's through the dining room, through the living room, to the out the side door, which everyone testified was generally where people went when they kind of left the house, where Michael went when he smoked his cigarettes. And there's also a front door. And the kitchen is accessible to both means of egress. And in this circumstance, there's no evidence before the court to suggest that she did anything to avail herself of the situation, even before she picked up the knife. But even after she picked up the knife, there's no evidence to suggest that she did everything she could to avoid physical contact. And in fact, the prior bad act suggests that she never shied away from it. She never shied away from the physical combat when it came to these arguments. And she was the one who often escalated these arguments to physical combat. And the last thing is that the defendant used no more force than reasonably necessary under the circumstances. Again, there has been plenty of testimony before the court that the defendant had used physical force against the victim in the past, that she punched him, that she gave him injuries, that she even harmed herself in doing so. And so to suggest that her only source in this instance, even if you were to find that her statements that he was manic and that she was scared because of his behavior were enough, which I don't think they are, even if the court were to find that, it didn't mean that she had to pick up a knife, because she had diffused situations many, many times in the past by physically striking him with her fist or however she hit him to cause him to have black eyes, broken nose, and bloody lip. So I suggest that those are all circumstances which suggest that she's not entitled to the self-defense. There was one more case that I wanted to cite to the court. It is an appeals court case, but it's Commonwealth versus Christensen. And that is, it's an unpublished case from 2017, where, and the unpublished site is 91 Mass App Court 1124. But that is a case in which the victim and the defendant actually agreed and made plans to engage in a fist fight. They had an argument over the phone. They engaged in this plan to meet up and settle it with fists. And that the defendant then went home. There's evidence in that case. The defendant went home, got a knife, and brought a knife to this fist fight that they agreed upon having. And in that case, the appeals court said because the defendant brought the deadly weapon to the fight, he's not entitled to self-defense. And again, in this situation, she brought the deadly weapon to an argument. For all intents and purposes, that's all these ever were arguments. It never resulted in a physical contact with a deadly weapon before today. And this was an argument. And she brought the knife, and she shouldn't be entitled to the instruction.
You want to address defense requirement that in order to raise the issue of self-defense, there has to be sufficient evidence that she attempted to extricate herself or took all reasonable steps to
doubt from the light most favorable to the defense. When taking the evidence, the light most favorable to the defense, if we take the statement to Angel to mean he was attacking me in the context of presumably meaning that the stabbing occurred while he was attacking me, then the attacking would have already been happening at the time of that deadly force being used. That's in the light most favorable to the defendant. Now, of course, we can write different stories in which she does not have that, but that seems to me to be a question for the jury. The case that was just cited about a guy leaving the scene of a fight, going home, getting a knife and bringing it back seems to be completely different than this case in almost every respect. But what is clear is that.
So are you agreeing? You're saying under the circumstances of this case, the paucity of any evidence that she took any steps to avail herself of retreating from the conflict basically shouldn't apply because she was already under attack.
She was under attack, which implies that she was being attacked at the time that it happened. And in light most favorable to the defendant, what that means is that at that point she couldn't retreat. And, or at least there could be a reasonable doubt as to that, which is the question. It's not, whether or not you accept the judge or you think it's likely.
The light most favorable to the defendant.
The light most favorable to the defendant for the question of self-defense came from the, the Ortega case that I quoted to you just a moment ago at 480 Mass 603, the evidentiary threshold for a defendant seeking instruction on self-defense is lower. We began from determining whether evidence warrants instruction on self-defense. We consider the evidence from any source and resolve all reasonable inferences in favor of the defendant.
But when there's conflicting evidence, then the court can take that into consideration as well. And so I suggest reasonableness of it, the court can take into consideration. And she got the knife before she's alleging that he lunged at her.
She tells Hunt she took a knife to defend
The
herself.
only evidence on the record right now of any burn of acts by the decedent is that text message to Angel. Where's the text message to Angel?
Exhibit 4. Do you want a black and white copy? Case which says that whether the evidence raises. Could I also mention the Galvin case, which says that whether the evidence raises a reasonable doubt as to whether predicates for self-defense is often a complex determination that a trial judge should, quote, err on the side of caution in determining that self-defense has been raised sufficiently to warrant an instruction. And that's the Galvin case at 701, quoting Commonwealth versus
What's
2.
the citation again?
It's 56 Massachusetts Court at, and the internal quote is 701. It's, I think, it's Galvin is 56 Massachusetts Court 698, and that's the pin quote is at 701.
All right, I'll take a look at that.
And also Ortega, which is 480 Mass 603, which I mentioned earlier. There's also Commonwealth versus, and I want to make sure that I get this name right, IACOBIELLO, Yacoviello at 90 Mass Apport 231, it's a 2016 case as well, which deals with the same issue of erring on the side of caution and giving the instruction.
Can I see or take a citation again, please?
Right, Mass 603. We've talked about the alternate theory a little bit in connection with the required finding and not guilty, but I'll hear any additional information. Commonwealth is seeking that instruction. I'll hear from you first.
I would just rely on all the arguments that I previously made in support of the motion for denial of the required finding.
Same arguments.
I'll hear from you with regard to the disagreement on voluntary manslaughter.
I think we also agree that it's the lesser included voluntary manslaughter, so I think we do agree.
Second degree voluntary.
So the only, I guess, disagreement in that would be in talking about the mitigations and whether excessive use of force in self-defense would then be applicable. The Commonwealth's position is if Your Honors finds that she's not entitled to self-defense as part of the more general instruction as to first degree, then therefore she wouldn't be entitled to it in those cases. Some of the cases I've already cited actually discuss that same principle, that if you're not entitled in one instance, then you're not entitled in the next for excessive use of force in self-defense. So that would be the only disagreement I would say as to that lesser included voluntary manslaughter that wasn't particularly, I didn't identify that in our proposed jury instructions.
What's the, I'll look through what you have, but what's the case that is the easiest one for me to look at that stands for that proposition that if self-defense is out, so too is prong 3 of the mitigating factors.
If I could just have 1 moment.
Sure.
The cases I've already cited do appeals court one. I think some of the cases I've already cited do say the same. I just can't place my hand on the exact citation, but I know another case that's an appeals court case, Commonwealth versus Toon, Toon. It's 55 Mass Appellate Court, 642. It talks about, it's basically the second paragraph of the actual opinion where it says, we conclude the defendant was not entitled to self-defense instruction at all, and therefore is not entitled to an instruction on the use of excessive force in self-defense. In that instance, it had to do with the voluntary manslaughter.
First, as an initial question to defense, do you agree, and I'm not pre-ruling on anything, but if the self-defense instruction is out, do you agree that A3 is out of the instructions on voluntary manslaughter?
I think that's a correct statement of the law, but can I have a moment to?
You can have until more than a
Tomorrow.
moment. You have to tomorrow, let me know, I can always put it back in.
I also found it, I'm sorry, Rodriguez, the SJC case from 2011. It also says that.
What's that on that, not a prosecutor?
It is 461 Mass 100, and it's at 109. It's a subheading that talks specifically about excessive use of force in self-defense. Before a judge may give such an instruction, the defendant must be entitled to act in self-defense. Thank you for indulging me.
Thanks for getting this right. The next point of disagreement is about the involuntary manslaughter, lesser included offense. The defense is seeking the instruction on involuntary manslaughter. Commonwealth has indicated that it doesn't think it's appropriate. Is that correct?
That's correct, Your Honor. The Commonwealth's position is just that the facts don't warrant involuntary manslaughter. Also, I find that when we provide the jury with some of those instructions that can can be convoluted and confusing. It dilutes the issues before the jury, and basically the facts in this case don't support involuntary.
Well, is that right? I mean, the distinction that's made with regard to the proof of malice, as required for all of the homicide charges, and the idea of what's associated with some intentional act, versus the recklessness that is found in the involuntary manslaughter. Isn't it the case that if this jury reached a determination that there wasn't sufficient evidence of malice, that a version of the events that would be believable, perhaps beyond a reasonable doubt, reasonably beyond a reasonable doubt, is that she held out the knife in a reckless and wanton fashion, and death resulted. Their theory of the case is that knife is out. She said to the police officers he either tripped and fell into it or plunged himself at her, and that was what happened. If it's credited by the jury, isn't that by its nature that reckless?
Possibly if you take that action alone, but we know there's a second wound that's on his back.
That one's hard to explain, but that's not the fatal wound, right? I take it that the medical examiner testified today that it was a combination of the wounds, or she said the wound. She didn't, to my hearing, say the wound number one. That is the wound that struck the heart.
Right, so my recollection is her testimony was obviously more extensive as to wound one, as to what the internal injuries were that would have led to the circumstances where he, lost half his volume of his blood and all of that. And I don't think, I think she identified that there were two stab wounds and one incised wound. But again, I think that
isn't that argument though for you to be making? I mean, it seems like if you credit what, and the jury can credit and they can choose not to. They may, I'm sure, you've asked for the consciousness of guilt instruction. I'm sure a big component of your argument is with regard to those statements shouldn't be credited at all because they were only brought to the attention after she was made aware of the fact that they'd uncovered the stab. But within their province to say that they believe it. They believe it. And the way that she describes it is that she was afraid. She took out a knife. She was scared. She took out a knife to scare him in response. And he somehow fell or lunged at her, thereby causing the deathly injury. Isn't that squarely in what the involuntary manslaughter charge encompasses?
I think it's a fair statement to be that it's the argument to be made. Obviously, that is the Commonwealth's argument to be made, that it's not that situation.
No, your argument is this was malice, that she intended to do this, intended to kill him. That's your argument. But a reasonable, it seems, alternate to that argument is what I just recited, and I won't recite it again. And that, to me, seems to squarely fall within the confines of non-malicious conduct that resulted in his death through reckless conduct. I'm not ruling on it. I'm just telling you, like I did with the other issues, sort of what my preliminary research on the law led me to. Think about that. I didn't mean to cut off your argument with regard to my musings. Go right ahead.
I don't need to put too much on. I think that is my position, that it could be parsed in that way. I would just point out the case of Commonwealth versus Tavares,
I have it, yeah.
Oh, okay.
Put it on the record.
And that same Iachiavello case, that 90 Mass Act 4231, particularly the facts as it relates to what they said went on in that case, in the part which describes the involuntary manslaughter portion under the B section of the analysis on page 1044 of that decision. I'm sorry, that's the wrong citation. 245 is that in that form citation. And
what was
the
the citation?
Tavares case is 471 Mass 430.
Specific to Tavares and specific to this case. Tavares is a little different. I was a little disappointed. I read a parenthetical about it. I thought, oh, this is the answer to this question. And I got to Tavares and wasn't so great because it really has to do with the impropriety of the prosecutor's argument. And the impropriety that was alleged was that prosecutors made the statement that simply by taking the gun out and pointing it in the direction of the decedent, that was malice. And the court in Tavares says that's not enough. That such a suggestion, when not combined with other factors that support the inference, is improper. Because although we've said that malice can be inferred by the act of shooting somebody, we've not adopted the same inference merely by pulling out the gun and pointing the gun. And then they went on to say that thus the prosecutor's reference that was malice in and of itself was wrong. But inferentially in there, in replacing gun with a knife, you can get to propriety of a involuntary manslaughter charge on the evidence, the limited evidence that we have here, which is that she took the knife out because she was afraid.
So, Your Honor, with regard to Tavares, I would point out that on page 437 of that opinion, it does say that the facts in Tavares would warrant an involuntary manslaughter instruction, not just simply that it was
Right.
wrong to for them to argue this issue of malice as a result of pulling the gun out. I would also point out the fact that in this case, they make the distinction that I made before during my argument, this notion that the reason for pulling the weapon is important in determining whether or not this was with the intention of acting in deadly force or simply do something short of that, like scare or ward off.
All right. If I do give the instruction, I'm not giving any pre-ruling on that, but if I do give the instruction on involuntary manslaughter, it seems to me that both A and B are then appropriate.
Well, I think A,
Look at 70.
I think A for sure. I'm not sure that this was in the context of a non-felonious veteran. So I'm not sure if B applies, but I think A does.
Yeah. All right, minors out. from the defendant on the use of a dangerous weapon. Exclusion. That's on page, on my version.
Okay, friends, I think that everybody's brains are tired because I am seemingly the only one still focused on this. So it makes more sense for me to catch up on this without you guys having to sit and listen to it. But I want to just summarize where we're at for now. Because I was taking notes as if, like, literally, here's where it starts. Oh, here's where it starts. And it goes on. And it goes on. And that's the last page. But it actually starts around there. So it's like 5.5 pages. So self-defense. She's not making rulings on self-defense right now. Lots of citing the Ortega case law. So if I do dig into things tomorrow, that's going to be one I need to look at. The defense is saying it's important that they see the pulling of the knife as not the instigating moment, but the response to a previous instigation. Okay. So that's why they want that in. Something that I made a note of here that is, I think, relatively new information to me. The wounds, according to the defense, are a result of launching at her or falling during a struggle. We've been asking about the back one, and the judge is putting a lot of emphasis behind the back was not the fatal one. It doesn't carry the same weight. So the defense says something happens. He is coming at her. There's a struggle, stabbings happen. Her pulling the knife was to ward him off, not to pull it on him. So to try to get him away, which according to what we read yesterday, isn't a good enough claim because she was supposed to try de-escalate. There were also 2 doors. Could she have left? But that's the reason to retreat. From all the case law that they were citing, it doesn't sound like that decision should be up to whether it goes in the instructions or not. I think it should be up to the jury. I made a huge note here that said none of these should be decided on until defense has had their turn. Because I think it's like, just to me, it's like really weird to make rulings when only half has been heard. But then she said she's not going to. I need to look up prohibition of chambers. This is a big one for me. If somebody throws a punch, no matter how much bigger they are than you, how likely they are to hurt you, throwing a punch does not rise to the level of deadly force. He could have decked her and she wouldn't be allowed to use deadly force. That is bizarre to me. Because if I was going to be kidnapped and someone punched me and then they were going to take me and whatever, common law is that it must be reasonable, the threat must be reasonable and imminent. when she went to grab the knife to scare him, that is Commonwealth versus Reed, not Karen Reed. 1998 is the case law they cited there on scaring him. And then if I wrote here, if he did anything to scare her, that would fall under Commonwealth v. Harris, 1978. She was supposed to do everything, and I underlined that 3 times, to avoid physical contact. The judge feels like so far just trying to read my writing. The judge feels so far that there is reason from her prior bad acts, essentially, to say that it wouldn't be a stretch to act unreasonably in that. I've got hiccups now in that situation. But she's not saying that it's in or out. She said she isn't anti-escalating physical contact, something like that. And that was Commonwealth v. Christensen is the case law there. Did she try to retreat? It doesn't matter. Did she try to retreat is what the law says. Defense says, doesn't matter. She was already under attack. Then I've got 4 different things for whether it's supposed to be whether self-defense is supposed to be in favor of the state or the defense. Obviously didn't go look those up yet. If she gets charged with 2nd-degree murder, then voluntary manslaughter would be a lesser included. Then there's a whole bunch more case law I wrote down. Involuntary manslaughter is what it sounds like the judge is leaning more towards, because involuntary has recklessness versus intent or malice. Her version has no malice, so it goes more to involuntary manslaughter, not ruling on any of these today. Then there's Tavares that the defense was using quite a lot. The judge said she didn't really agree with it because it sounded more like it was about prosecutors' misconduct. Defense says the reason for pulling the weapon is important to find which one it falls under. And they are going to look into use of a dangerous weapon next, which is the part of it that I said was going to be so difficult because of what counts as a deadly weapon. I've got a cold sore here. Oh, it's going to be sore. I'm going to pause this now, though, because I've run out of brain power. And we could do it some casual. I'm going to put this on for a little bit. Everybody needs to behave, please. I need to go find the stuff to put on my cold sore. And we need a brain break.
Maria, do you know if you replied? Really? You think that quick? Great. Okay. Yeah, set it for Monday. And then, wait, did I give you Cedric's phone number?
No.
Can I give that to you? Do you mind reaching out to him? You know what? I emailed him yesterday before we left. I wonder if you replied. Victoria, do you know if you replied?
Sorry, I just saw one thing that I forgot to mention. The arm brace. I think my science, what do you call it? The person you experiment on, I think he's sleeping. The arm brace would also depend on how she holds the weapon. And in fact, I can prove it.
I CC'd you on the email too. Let's see. Now, today's what, Wednesday? Right? Okay, you ready? Let me just give you this phone number. This is his cell phone, okay? 713-702-1574. His name is Cedric Taylor, works for the Los Angeles, or no, he works for TLC Wellness, right? But perhaps he knows how and if we can get Mr. Bueno into this housing place.
I'll reach out today, Your Honor.
We tried to call, Logan and I tried to call this housing complex yesterday and like the number wasn't working. I don't know, but he replied and so.
I did try to call the number you gave me multiple times. I haven't got anything. But I reset him for Monday. And
Does he know who that was? What was the name again?
her name was Diane and she
Do
said.
you have a last name? If you can get a last name, then I can try to look it up.
Okay.
I could put it in the global list and try to look it up.
Will do. And the last thing, since my dad was in the army about, why did he stop screaming? He clicks in every single day to watch.
Right?
Yeah. So
Who's screaming? Me?
no, my dad always been asking lately, he's not streaming no more. Why is he really streaming?
Who?
My dad. He watches every single day.
Right?
Every single day. But since he stopped, he's just been.
Well, tell your dad that you do an excellent job. That we love you, you know?
Thank you.
For sure. Yeah, hopefully. Yeah.
Judge, I'm
Hey, Ricardo.
On a client, Mr. Guillermo Morales Duran,
In custody on bond.
he's on bond, Judge. Now, I needed to approach because you put a condition.
Can't find my arm
to be
brace.
Educated. And so I was trying to get a reset on this case.
What is Mr. Morales doing now?
Well, as far as education or working?
Both.
Well, working, he works at a nice restaurant called El Jardín. It's where Mamacitas first started, I believe. They're related to the Mamacitas chain. And so he works there. He's been trying to.
This is the gentleman who's our age who can't read or write.
I believe so, yes.
What is he doing?
So he's gone to different locations. I told him to go to a location called AMA. It's a Hispanic organization where they help the Latin community with needs. The first time he went there, they said, hey, we only got classes for kids. So then they put him in touch with the consulate's office. He went over to the consulate's office. They said, they sent him somewhere else to Baker Ripley in his neighborhood. He went to Baker Ripley. They said, hey, we don't do that. We just do employment. So he went back to AMA. They sent him back to AMA. And so he talked to somebody different there. And so there's a class that he could go to, but the class that's current is already in session. So they can't put him in there. The next availability is until September 9th. He's struggling with finding the transportation to figure all this out, and he's got limited means to do it
I'm gonna
online.
reach out to someone now. So bear with me a second.
Can't find my brace.
I have other things to do.
Yes, Judge. The only thing I was gonna say was he's got a plan in place. Hama is kind of just a metro trip down his, because he lives in the area, sort of. It just takes one trip from Metro to get down there. So it's a viable solution if you allow him to wait till September 9th. It's a great organization. And
Okay, I'm gonna also reach out to the MAC to see what other things that we have, other resources that they may have perhaps, and they can also help pay to try to help them, learn how to read and write.
There's a lot of stuff online, Judge. The problem is he can't afford it and he's not.
That's what I'm saying. I'm gonna see if I can pay for it for him,
Okay,
right? So just bear with me. I just need a bit of
I'll
time.
come back on that one.
Okay.
Okay, I'll do
Is
that.
that it?
Just for the regular docket, yes.
Okay. Okay.
Appreciate it.
Okay, I'm gonna share this. So mine is much like this. And so, because for me it's for thumb strain, so it's quite easy to still keep my hands like that, but the gripping is more difficult. So it feels strange to me that with that limited movement, she would have enough strength. And hers is like a hard cast. You can't make it a fist. Yeah, I really wish I had mine. But you guys have seen me wearing it. You saw me wear it when I was in Zurich, for sure. I definitely wore it in Zurich, and I definitely had it for parts of my travel in Edinburgh. Yeah. I'll share my screen in a sec. I think here I'm literally busy putting it on. It's like a Vickyception. So I'm using that glove is like an arthritis glove, compression glove. It just helps with the rubbing thing. Apparently I'm going to take 25,000 years to do it. Yes, the thumb and it's my thumb, it's my tendon in my thumb. So that's just like a piece of material, and then basically arthritis glove, compression glove, which is a bit too loose for me. But that fabric, there you go, you can see where the metal thing is. And I'm not even putting it on like 100%. I left my thumb out because sometimes it just gets so frustrating. Oh, wait, I did do it properly there, I think. No, I didn't. But my hand is essentially like stuck like that. Like that. My thumb is through it. So you see, I can still grab things, but it's not like, it's very stiff. I'm going to throw this out there. I've used them. The metal can be removed and still manage to have enough grip to control or push my wheelchair. That's interesting. I can't take the metal out because I don't know why my one, like I probably could cut it open, but when I was traveling, I had to take it off, put it in the thing to go through the metal thing, put it on the other side. Yeah. Anyway, I need to quickly see what's going on out there. I think Vaughn's probably waiting to go to bed, but I'll leave this on for a little bit while we wind down. No late nights tonight, though. Last night was way too late.
How are you?
Morning, Judge. How are you?
Hey, what's up?
Not much. I'm here on Chandra Moss. I approached on her last week. I can't remember if it was Thursday or Friday. It was the fugitive who you agreed to give a bond to, but you wanted her to be here in person. We tried to set her on docket for Monday, but I don't know what happened. There was some sort of glitch and she didn't make it on the docket. Oh, are Day and Amy there? I can't see them, or am I just?
No, they're not here yet.
Oh, they're not here. Well, then let me
No.
wait. Let me email them and wait till they get there. Then, Judge. Sorry about that.
I'll text Day now.
Okay, thanks. Oh, but is Garza there? Deputy Garza, were you able to bring her up or no?
I have not got her up here. I'm calling the pod to see if I can get her up here.
Okay. Yeah, so they didn't bring her up, and that's what I was gonna say, because Amy and Jay have been emailing me about that. So I know that you wanted her up to admonish her, so I'm hoping they can bring her up, but if not, I'm gonna beg you to set up on anyway, because I talk to her mom like every day. It's not like they're not gonna know what to do.
Hey, I'm gonna try to get her here.
Sounds good. I'll hang tight. Thanks.
For sure. You said Moss? Did she say?
Yes, Chandra Moss, Judge. MOSS.
Mr. Fleming.
Good morning, Your Honor.
Hey.
I have Melvin Morales Soto on docket today. Need to approach just because the age of the case, and maybe, I think it's under Morales. Melvin is in the audience.
Thanks. Yeah, it's what we're doing.
So we have everything signed as far as the PTI contract. He needed a little bit more time to get the DAP and stuff. He's been out of work from the storm and other things, trying to catch up on bills and such. So he needs more time to get the payment for that and the device.
Where is he?
Yes, sir. Come this way.
Does he have the interlock?
No, he doesn't have that yet.
It's Morales Soto. Tell me, when can you have the rest of these?
I can have it by next month, by the 15th. That's my next free check. I just haven't been working because of the.
If that's about 2 weeks from now, I'm willing to give you that, but your case is 190 days old. Should happen a long time ago. I will not give you any more time after that. Do you understand? I will acquiesce to you now. I'm giving you what you want, but you will be out of time after that. Do you understand?
And that includes the.
You need the interlock.
$100.
You also have to pay the DA fee, correct? Yeah. If you have any issues, go to, there are other providers around here that can either put you on a payment plan or you tell them that you're indigent and then they can reduce the fees, but it's your responsibility to find them. You must have this done within the next reset. All right? Okay.
Thank you, Ron. That's all I have today. Maybe excuse, you just take a seat.
I don't know.
Right there.
What's
your name?
Ink.
What you do?
It's ink from the pen, probably. Yeah, I know.
Let me take it to her.
What? Oh, I don't know. Hey, what's up? Where you at this day? The chief? Yeah, are you the chief?
No, I'm not the chief. Scott Hutchins. Yeah.
How goes it?
I've only started this week.
Oh, okay.
Yeah, so I've been here for a couple of weeks.
Have you been to felony court yet?
I think that's what I come by.
Okay. Good. I mean,
only
you
have
got
like 80,000.
How many trials have you had since? Have you had any? Just ours. That's it.
That's it.
That's the problem. You know, you need to get that, and then once you start doing that, that's when they'll move you upstairs, because you've got the time. You know?
I think we'll be, especially when you're felony.
Yeah. Well, they're always trying stuff.
You met Kim. Eh?
Oh. I don't know. Look up Herndon. Is he? I don't know if they would bring him up. Oh, I have to sentence him. Hey, Stephen, is Herndon up?
I specially requested him, but he did not make it. He was still in PC court.
Why?
When my paperwork shows that he was in PC court for the new case.
Oh, he picked up a new case.
He picked up a new
No.
trespassing case.
Did you know that?
No, but that's why he was picked up. Not on the warrant, he was picked up because of the trespassing and then the warrant.
So where's
Oh.
where's that?
And they gave him a PR bond on the new case.
Yeah, like he ain't getting out.
No, that's why when I saw that, I requested that he did not.
Oh, looks kind of
go,
rough.
but to come to us
Looks
first.
rough.
Is it that one now?
You look, no.
Yeah, it looks completely different than what he did.
Yeah.
Wow.
It looks a lot different now. So we need to sentence him. So I hope,
Well, that's why I wrote it into the transport. for
you know what, I'm gonna call,
Let me call, JPC.
I'm gonna call you. What do I do?
I make a luck tomorrow.
hey, you got a second? Can I give you cost number? 0721.
Oh, yeah, a little. He's on.
So Mr. Herndon and I have a long history, and we tried a case, I want to say about 6, maybe 7 months ago. And we set him for sentencing, and he never showed up. I ended up sentencing him anyways, and he's been just MIA for the last, since we sentenced him. They finally picked him up because he picked up a new case, another trespass case. It looks like the magistrate has given him a PR bond on the new trespass case, but I want to make sure that they don't release him because I need to sentence him on the trial case. Yeah, and I'm hoping that they don't release him. Okay. Yeah. Hey, recall the GOV, please. On Herndon, they gave him a general order bond. On the new case, recall that. And then, I guess I'll just. And then I'll just, that he's just a flight risk, I guess. We can never, we just can't get him to show us, No. Yeah, hey. Okay, I guess we'll do that. I want to make sure that this happens before he gets, if and when he gets released, because I don't know if they're gonna release him. And- Okay, so that means that they're gonna keep it. You can postpone. It says no bond. Right? I mean, I'm showing that there's no bond set. So no. What happened was he appealed. So we went to trial. He lost. I sentenced him and he filed an appeal. He never did anything with the appeal. We sent him mail. We sent him certified mail. We sent him emails. We sent just about every medium you can imagine that we called him. We sent him every medium that we could. He never responded to anything. So we ended up having a hearing that he has failed to request any kind of record, reporter's record, clerk's record, anything. And so the appeal was basically denied and it was over with. But so now what's left to do though is sentence him on the original trial so that he can do the time. I have Steve in my bailiff trying to locate him to see if we can try to get him, but
A little bit.
I do know.
how long is it going to take for him to get stressed out and housed? No, yesterday he's been in for at least 24 hours because we spoke about this yesterday. And maybe that's why they gave him a 3 week. Sheriff's office couldn't get to him, or the magistrate couldn't get to him. There's just too many damn people getting arrested. Okay. Okay, great. Thanks, Sylvia. Okay. I have administration trying to locate him.
I have them also.
Because, she's telling me that they're not going to send him up until they house him and dress him down.
Are you gonna put the same on them?
Yeah, I'll leave it at 100. I'm not going to touch it, right? But recall the GOB, and then I'm going to try to get him as quick as we can.
Don't call it. Super student.
Okay. Hey, good morning. What's up?
I see where your Christmas. Okay.
My Chinooka, Hanukkah, yeah, or Christmas, yeah.
Judge, I'm back on Mr. Trim from yesterday.
On who?
Trim.
Oh, Mr. Trim, yeah. I don't know. I'm not gonna take a time served on it. And I don't know where.
The court consider a 30-day offer on that one. On the fraud.
What do you think of that, Pavel?
Judge, in my humble opinion, I don't think this is not a deferred guy that's gonna follow all our conditions.
Right.
We're just gonna be back, and it's on a fake plate case. Frankly,
He said 30. Are you okay with 30?
I don't, yeah, I
Okay, I'm down. Yeah, for sure. Okay.
Hey, Judge.
Hey.
Let me do I'm gonna do the easy one first.
Harrington, come on up. Okay.
I'm good to speak.
Easy first. Yeah, for sure.
Shannon Joel Gutierrez.
Thunder Gutierrez?
Yeah, I think you required his appearance. Discovery's in, I watched everything. He's not.
Wait,
It is waived, okay. Because
So.
you had kind of wanted him to
Mr.
find a
Gentleman,
job.
Do you
So-
have no phone number?
He calls randomly. I'll try, that's okay. I was gonna ask for more time if you needed to be here, because everything
No,
is in.
I don't need him to be
Okay.
here,
So I'm gonna reset him, requires appearance.
but he has contact with you, I guess, because you're.
Well,
telling me
everything's in. It's either he can set up trial or just plea it.
It's a trespass,
Right.
and he has a lot of history. Logan, what are you looking for? What are you looking for, Mr. Gutierrez?
Fair enough.
You let me know, Greg.
Okay.
I'm cool with whatever you want.
Okay, so I'm just gonna reset him and require that, he's the guy that you had wanted to show proof of employment, and he had the piece of paper that said he was doing some home health care, helping some elderly, I don't know if you remember, but anyway, that's why I approached. Okay,
Is he working now?
I mean, he says he's working,
I mean, it's a relative term, right?
I mean, he provided some piece,
Working on my tan.
provided some piece of paper, but everything's in, so I was either just gonna.
Okay, yeah, all right.
Okay, so I had it here, so I was gonna try to.
It's waived now. It should have been required if that was the fact, but
Okay, well,
it's okay.
yeah, anyway, cool. So I will get a reset on that. And then the next one is Miguel Garcia. He's the young kid that tested positive twice, that you had revoked his bond. His mother is here today, so is his sibling. So I was gonna see if you would reconsider his bond or give him a general order PR bond again. But mom is here.
Where's mom?
She's in the back.
Okay. Do we need a translator for mom?
No?
Okay. Do you mind bringing up Mr. Gutierrez?
Or Garcia.
He was in pre-release and they're catching him going.
Pre-release?
Because of the GOB bond.
But.
I understand. So I got him moved to classification so that way he can get housed and he can get to us. Just like, you know.
I swear I can just lose it. I'm just gonna release someone who's supposed to do a 6-month sentence. We'll never see them again.
Mine's Garcia. Miguel Garcia.
But luckily I was on the line with all of them.
Great job, Steve. I swear.
And Amy Moss should be heading our way shortly. I saw the GOB bond this morning, that's why I did a special request this morning.
The reason is because he did not get in front of a magistrate within 24 hours. And so that's why they just gave him the GOB and they were just gonna let him go. But the problem is that we have to sentence him. And if they release him, we're just not gonna see him anymore.
Friends, I think it's time to go as well. I need to crack on and get to bed. But I will catch you tomorrow. Time TBC. But she said 10 for the jurors, so it might be a little later than today. I will try to read a little bit of this case law, etc. tomorrow. All right. Have a good evening, afternoon, morning, wherever you are. Bye.